I permit you to mention one matter, urgent matter.
Extension of interim order, please hand over the slip mentioning the date when it is going to expire. Yes.
One urgent matter, municipality matter, my lord, I have to mention it because municipality, Mohanstala municipality is going to acquire my land by making railing on that to make a park. Without consent, nothing has been, not acquisition. Let it be.
Mention the urgency, hand over the slip.
I am mentioning, let it be tomorrow.
Yes.
Let it
You
be tomorrow.
please serve notice upon the other side. List and determination of Justice Chondo, please mention the urgency in the slip and hand over.
We have mentioned, my lord, we have
Of the list of Justice Chondo. List of Justice Chondo, anyone? Hand over the slip.
স্যার আমি বলতে পারি
Justice Chondo list আলাদা করে রাখবেন।
স্যার স্যার আমি একটা সিভিল স্যার
Yes. Upgradation, please hand over the slip mentioning the urgency.
স্যার এক সেকেন্ড স্যার
My lord,
আমি একটা সিভিল স্যার আমি একটা সিভিল ডিভিশনাল অ্যাপ্লিকেশন ফাইল করেছিলাম, তো সেটা যেদিনকে মানে ডিসমিস হয়ে গেছে স্যার ডিফল্টের জন্য, সেদিনকে আমি সুপ্রিম কোর্টে ছিলাম স্যার, তো সেইখানে একটা সিভিল ডিভিশনাল পিটিশন
অ্যাপ্লিকেশন ফাইল করেছেন, স্লিপ দিয়ে দিন।
may I have my lord's kind leave to mention one matter. Lordship is quite urgent. I mentioned earlier also, both the parties are senior citizens and it does not appear for the for a single time. Let it appear tomorrow, Lordship. Lordship, may I pray that let it appear in the daily list?
Hand over the slip.
Lordship, I handed over it, but unless Lordship directs them to allow to appear tomorrow in the list, it will not be done, Lordship. I'm honestly praying,
Ask
Lordship.
any of your juniors to hand over the slip. Mention the urgency, hand over the slip.
May I be
Yes,
permitted
Lord.
may I seek leave to mention a matter, my lord?
Aim for inclusion, Lordship. Division bench measure, please mention in the month of April. After 15th, please mention.
My lord, may I seek leave to mention a matter?
Lordship, kindly, I mentioned on Monday. Your Lordship had asked me to mention today. This was where a property was purchased in auction, company auction sale in Delhi. The same property gets sold through DRT. So we approach the Delhi High Court. Delhi High Court says go to DRT. DRT says we can decide the application. Right title interest can be decided in DRT. The other side challenges that before Debt Recovery Appellate Tribunal. That gets allowed. That order is upheld. The appeal is not allowed. That order is assailed before your Lordship. I am the opposite party. I am mentioning upon notice. This has been pending, and for the last 1 year, they've been taking adjournments and nothing has been happening in the Debt Recovery Tribunal in the matter. I put in 7 crores and
Mention the urgency, hand over the slip.
could it just come up on any day? Lordship, we'll just consider it.
লর্ডশিপ
Upgradation.
লর্ডশিপ লর্ডশিপ আমার ম্যাটারটা হচ্ছে একটা হচ্ছে
95.
একটা হচ্ছে অ্যালাউ করেছে একটা প্রথমটাই অ্যালাউ করেছে
Not going to 95. Tomorrow is the date. What is the order under challenge? He's appealing for the other side. Mr. Chatterjee, do something because I do not know whether this can be taken up today. Because prior to tomorrow is today. Today, Mr. Chatterjee, there is a division bench from 3 p.m. Please. That is always there. Even if it is not there, you are not praying for adjournment, Mr. Chatterjee. Yes.
লর্ডশিপ
Yes, let me see. Yes.
আমার ম্যাটারটা অনারেবল জাস্টিস কৌশিক চন্দ্র ঘরের ছিলেন, আমি তার জন্য এখানে ডিটারমিনেশন রয়েছে তাই মেনশন করতে এসেছি। লর্ডশিপ আমার অলরেডি জাস্টিস অনিরুদ্ধ রায় অলরেডি একটা অর্ডার দিয়ে দিয়েছেন ব্যারাকপুর মিউনিসিপ্যালিটি
আর্জেন্সি যেটা আপনি এক সপ্তাহ ওয়েট করতে পারবেন না।
একটা দিন ওয়েট
আর
করতে
দুদিন
পারবো
ওয়েট করতে পারবেন না?
একটা দিন ওয়েট করতে পারবো না লর্ডশিপ। আমার ওয়াইফের অপারেশন যদি না হয় আমার ওয়াইফ মারা যাবে, এই সিচুয়েশন একবার দেখুন।
ঠিক আছে, দিয়ে দিন, আমি দেখবো, দেখে যদি মনে হয় fix করবো।
কালকে যদি ভালো হয় মাইলর, আমি আরো স্যারকে নোটিশও করেছি।
ওটা জাস্টিস চন্দ্র লিস্টে
My lord,
আলাদা।
plain thought in court, my lord.
What do you want?
My lord, caveat is there. In spite of that,
What do you want?
finally, matter to be appeared in the to be mentioned, and
Why?
said that.
For what?
Caveat is there, my lord.
Yes,
It's
why
part of
to be
the-
mentioned?
So how can matter to become, my lord? I am not the party now.
Why you are not the party?
Without service any copy to the caveat.
Yes,
Order has been passed from this court, my lord. Honorable court. For that,
there was a caveat.
yes, my lord.
To be mentioned দিয়ে দেবেন এটা।
Your lordship may be permitted to mention.
Mention tomorrow. Who is appearing for the petitioner? Please serve him our notice. Please serve him a notice.
Appellate.
Yes,
Your lordship may be permitted to mention one CO that has been filed on 14th of August. Still, it is not in the list, my lord.
please hand over the slip for addition.
My lord, my lord.
My lord, may I mention, my lord, one matter? My lord,
When it is expiring. কালকে দিয়ে দেবেন extension of interim order. For inclusion, hand over the slip.
my lords, my lords,
Please hand over the slip for inclusion, for upgradation. Please mention that you did not. For expeditious hearing, please do not mention. Lordship, please do not mention for upgradation for expeditious hearing. Lordship, to mention urgency in expeditious hearing. To mention for release, my lord.
My lords,
To mention for release. Mention for
my lord, item number 108, my lord. For item number 108, my lord, I am for the petitioner advocate on record, my lord. My lord,
Yes.
can it be fixed at any day at 2 p.m., my lord?
No, no, no.
my lords are
My lord, obliged.
listed on.
What do you want?
My lords, listed together on Friday.
Please speak on the microphone.
My lords, four civil revisions, 3 of them were listed on 20th March. We have sought an accommodation. You were filing a 4th petition that has been filed. It's listed on Friday. Kindly list the other 3 together because they're emanating from a common order. So same issue, same point of law.
Not that
My lords,
will appear in.
my lords, one of them is listed on Friday. My lords,
Yes, Mr. Mukherjee. When? এটা interim order, extension of interim order. My list or Justice Chandro's list, extension of interim order. Yes. Inclusion,
Lord,
please.
may I seek leave to mention an urgent matter, my lord? Lord, may I seek leave to mention an urgent matter?
Lordship, item number.
Urgent.
Monday.
962.
Hey, just সই করেননি তো? It was, an order was passed in 2024. Can you not wait for 2 days? Execution, you can wait for 2 days. For 1 year, nothing happened. Please wait for 2 days. Yes, no. Just, what is the urgency, Mr. Chakraborty? Restoration is not urgent. Nothing will happen if it can be removed. Nothing will happen.
Lordship,
Yes,
Lordship, one matter, Lordship, this court has engaged one mediator. Lordship, we appeared before the mediator. Now, Lordship, already this court passed a stay order. Those stay order has subsequently expired. I am for the opposite party. But Lordship, our entire development project, I am the owner of.
what do you want?
Lordship, the item number 16016 matters, Lordship, pending before your Lordship. I am
Yes.
paying for some upgradation, Lordship.
160 in the supplementary or monthly?
962 in the monthly list.
Mention the urgency. Do
I
not
have mentioned mediator has been engaged. Lordship, kindly fix
please
the date.
mention the urgency there. I will consider.
Lordship.
Filed within 30 days.
Please hand over the slip.
In item 101, Lordship had directed the matter to appear, it has appeared. But the judgment would be passed on 3rd of April. I won't get an opportunity to
100.
send one. Notice served, again for mentioning notice served. 3rd April is the date for passing of judgment in the trial court.
Yes. Hand over the slip.
My lord, one listed motion, my lord, one listed
What do
motion.
you want? For inclusion?
For inclusion.
Inclusion, please hand over the slip. You did not mention. I have asked you.
My lord.
May I be
permitted?
Only
Only
disposal,
I will give an
only disposal of that.
Early disposal, it is appearing in the list.
No, it is not appearing. And so time and again, I have mentioned before. Time and again, this is a partition to 2020.
Have you mentioned again
Time
before?
and again, yes.
See what is the endorsement in your mention slip, then mention.
No, kindly for inclusion, only what inclusion.
See what is the endorsement?
Only there is reflection that was rejected. Only there is no ground. Kindly.
Yes, if it is rejected, please mention in the next month.
Father, may I have your lordship kindly to mention very urgent in this matter.
You are not audible. Please use the microphone.
Your lordship, the shop room is in a dilapidated.
What do you want?
Lordship, inclusion, your lordship. Lordship, it is very urgent because the
Is
shop
it
room.
motion
Yes,
or
Lord.
hearing?
Motion.
Motion, hand over the slip.
Very urgent matter, your lordship.
Your lordship, may I permit to mention, your lordship? Your lordship, may I permit to mention, your lordship, mentioning for upgradation, your lordship, that the article is.
No, we did not mention individually. Please mention the urgency in the slip. Hand over the slip.
Yes, your lordship.
And
it
if
is
you want to individually mention, yes, I will hear all of you. Let me see how long it will continue. I will not take up any matter. Please mention individually all the matters.
Review application from your.
I'm telling you urgency, please indicate, hand over the slip.
My lord, may I be permitted?
Want to mention individually, I have no problem. I can hear all of you individually. For mentioning, I will take mentioning up to 12.
My lord, may I be permitted to mention one matter?
What for, madam?
The petitioner filed an application and.
Please hand over the slip. Where you
May
mention?
My
I
lord,
seek leave to mention a matter, my lord. There is urgency in the matter, my lord. My junior is there in the physical mode.
no lordship.
My lord, may.
Day.
Yes, lord.
Yes,
When-
my lord, the demolition is scheduled today. My lord, the demolition is scheduled today, my lord.
When
My lord,
the
my junior,
was passed,
my lord, what has happened, I tell your lordship, my lord, in the year of 2023, we have purchased the property.
No,
We
when
had
the
no
order-
knowledge.
please answer when the order of demolition was passed.
My lord, there is no order of demolition. What has happened, I tell your lordship.
It will
In the
appear.
year of 2000, my lord, kindly hear me for a
It will
moment, my
appear.
lord.
Oh,
There are-
yes, Mr. Sarnan.
My lord, the petitioner will be dispossessed from the suit property as the nature and
What do you want, madam?
my lord, we want a date for hearing before 2/4/2025. Otherwise, the learned trial court is hearing the matter, hearing the matter when it is fixed for it is fixed for hearing. Before that, we want a date for hearing.
Is it appearing in the list?
No, my lord. My lord, otherwise they will be in grave difficulty.
Hand over the slip. Have you mentioned the urgency?
Yes, my lord. Yes, my lord.
Leave to file without certified copy, section 47 has been rejected, lordship. Now,
Why leave to file without certified copy?
apply the certified
What is the date of the order?
date of the order, lordship, quite long before, lordship.
So when did you apply?
Yeah, I applied tomorrow, lordship, I will get it, but the.
You applied tomorrow.
No, lordship.
Yesterday, yes.
Yes.
But the
So,
day after tomorrow,
we-
lordship, Friday will the date for lordship execution.
You could wait for 1 year, file with the certified copy.
Liberty was given lordship to file after there was some defect. After that, lordship, I once again lordship applied for the certified copy. Now, lordship, by that time, lordship, police petition has been allowed, lordship.
Restitution can be done
Now,
if it is allowed.
finally, lordship, allowed to lordship by the next date of hearing, lordship, I will lordship undertake to
So
produce
file it, give the number
lordship certified copy till date, lordship, did not have.
without the certified copy. You have annexed the server copy.
Certified copy I have.
Server copy is there. They can even without certified copy, but with the server copy. Server copy na থাকলে দেবেন না.
My lord,
And another lordship.
my lord, may I be permitted to mention one matter? I'm praying for leave to file this CO before this regular bench in the department.
Why you need leave?
My lord, because department is not taking it.
Why?
Because department is saying that this is a section 24 matter, and
Yes.
the husband, he has filed this restitution of conjugal rights matter in Jalpaiguri.
Yes,
But
you have to file there. Yes,
Milord, there the circuit bench is vacant right now. So they,
circuit bench will be available from next week. Yes.
The
Milord,
application was rejected, Lordship.
Milord,
Madam, circuit bench will be
this is
available from
expense,
next week.
Milord.
File next week.
The
Milord,
application was
previously,
rejected.
Milord has already give us leave to file this matter here also. But
Yes.
The application, Lordship, in connection with order 21/97 was rejected, Lordship. Now, Lordship, 24th was the date, Lordship, when due to medical urgency I could not appear, Lordship. Paid for not. Lordship, your Lordship directed to appear the matter, Lordship, in the month.
We will appear in due course, Mr.
Lordship,
Shanwal.
2nd of this month, Lordship, is the date for execution, Lordship.
Hand over the slip mentioning the urgency.
May I have your lordship's?
Yesterday, Malad, I mentioned that matter. Injunction, because they are in the
Which item?
because they are 24th. Yesterday I mentioned that there is the order injunction. 3 matters were on outer list. Your Lordship.
Hand over the slip mentioning
have
the
your-
urgency.
May I have your lordship?
Because there. Because there, my lord, may I?
You mentioned with the date tomorrow. And the trial court has already started
Please hand over the slip mentioning
May
the
I-
urgency.
May I have your,
with item number 73 of today's list. My matter is trial to started.
Maybe.
Matter may be fixed.
may I hand, may
I
I,
cannot fix the matters according to the dates of
May I
the
be-
trial court. Yes,
may I be permitted?
maybe. Yes.
in your lordship's list, my lord. Mention before if the matter comes not taken up before 27.
Let me see, I will proceed serially.
Expeditious
Yes.
disposal, my lord. Very, expeditious disposal, my lord.
No
May I,
urgency.
may I have your, may I have your,
That was returnable last year, November. Thereafter, I had mentioned it twice.
There is no urgency in expeditious.
Why the
disposal matters.
difficulty is more than 7 years old, my lord, the matrimonial proceedings, my lord. But no steps have been taken, my lord. Some
You hand over the slip. We'll
may I have your lordship's kind leave to mention one matter, my lord? I am
Lord?
sorry to trouble your lordship, my lord.
Lord?
May I have liberty to move an urgent unlisted
Mention.
motion at 2 p.m. with
Why?
leave granted by your lordship?
What is the
Because
urgency?
the urgency is that a notice inviting
Alright.
tender was issued and the private respondent was supposed to be given the work order either in course of today or by tomorrow. Although I am
Municipality matter
municipality matter, yes.
of Justice Chando's list.
Yes.
Tender matter is group 9.
No, but it's arising out of this PWD, Public Works Department.
Not a municipality matter. Yes. It's a group 9 matter.
My lord, Group 5, it can be filed in
No,
Group
no.
5 also.
It's not a municipality matter. Yes.
So, stand permission, my lord. Your number 2577 of 2024 and 2586 of 2024. My lord,
What do you want?
my lord, I want for inclusion in the monthly list, my lord, because
Please hand over the slip.
on the upgraded position, because opposition.
Let it appear in the monthly list thereafter as well.
My lord, one is the senior citizen, my lord,
Maybe.
and other side is obtained a stay eviction proceeding, my lord. They have 4 months has been already passed, my lord. Kindly make it.
In the April, I will do one thing. I will upgrade all the matters of this monthly list in the supplementary list.
In a monthly.
All matters will be upgraded in the supplementary list. Happy?
My lord, may I have your lordship's kind leave to mention, my lord, item number 750 of the monthly list, my lord. I would not have disturbed your lordship, my lord. The urgency is that, my lord, the court.
Please mention the urgency in the mentioning slip. Hand over the
My
slip.
lord, I have already mentioned it, my lord.
I will
Just one
return later.
indulgence. Just one indulgence, my lord. My lord, kindly, my lord. Just one indulgence. The interim order, my lord, this is a suit for partition, my lord. The suit for partition was filed. They have moved the injunction application, my lord. Injunction was granted with a condition. After granting the order of injunction, my lord, it was vacated by the court on 19th of December 2024. On 20th of December, the plaintiff comes up with an application of under 151 and says that it was vacated, now reinstated, my lord. And that application was allowed, my lord. That could not have been done, my lord, in my humble and respectful submission, my lord.
All right.
My lord, kindly, my lord, allows it, my lord. I would not have disturbed your lordship, my lord. Fourth is
Yes,
the date.
your lordship.
Yes, for
My lord,
release.
may I mention, my lord, I mentioned it lots of time, my lord. Lordship asked me to mention it later, my lord. Though it's for expeditious hearing, my lord, but the urgency is, my lord, 7.1, which is section 5 in 7.1 is pending since 16 years, my lord.
My lord, kindly take it is appearing in 546 in the monthly list, my lord.
My lord, for listing.
My lord, kindly.
Rejected, yes.
Item number 890 of monthly list. The petition application has been filed against the rejection of my application to get to repair the farm, which is the only.
What do you want?
Sir, I want the petition. Lord, kindly accommodate any date, because I am suffering day after day. Lord, this is what regarding the water connection. I am suffering for since 2000.
And about the sleep, yes.
Yes, sir, is item number 8. Item number 8. Maximum just the lady is running since 2017. Without fixing dates twice a week. She's suffering.
What do you want?
These are the matters.
It will be taken up in due course, yes. Mr. Rai, I have asked all of you to mention the urgency and to hand over the slip. Please go through the mentioning slip. Each and every mentioning slip, some endorsement is there. Even if you want to mention it again, you can hand over the slip.
listing of it.
Mention choice is yours.
Like yesterday evening, my lord, the police officials have come that today is the demolition. 400 subsection 8. There is no provision for an advance notice, my lord. They are going to execute a demolition order of 2018 when I was not even the purchaser. I've annexed the deed of when I've.
Which municipality?
Kolkata Municipal Corporation, my lord.
Tomorrow.
My lord, it will be demolished today. My lord, may I come back at 2, my lord? May I come back at 2, my lord?
Who is appearing for the Kolkata Municipal
But I'll
Corporation?
serve the town hall and come back.
My lord, item number. My lord, item number.
853 of the monthly list. I'm the ticket holder.
But can you not hand over the slip? Each and every matter you will have to mention.
My lord, item number 6 and 7 of.
I'm asking you on each and every matter in the monthly list you are mentioning it.
My lord, item number 6 and 7 of your lordship's today's list, my lord, are the same and identical matters. 7 is fixed at 1 p.m., my lord.
6 and 7 both will be taken up at 1.
At 1, my lord. Grateful, my lord.
6 and 7 দুটোতেই তো লিখবেন শুধু 7 এ 1 pm লিখেছেন 6 টাতে 1 pm লেখেন ও হেডিং এ তো 1 will take it up at 1 pm. Please inform the other side. Yes, call the list. On the list.
Item number 1.
Release the matter.
Release. Since I'm not.
Lordship, in this matter, I am appearing for opposite party number 2. Full Lordship.
Opposite party number 2. You are for the petitioner.
You're led by Parthopotin Roy. Lordship.
Led by?
Advocate Parthopotin.
He's busy counsel.
No,
He has gone to somewhere else.
Small in height.
Yes, Mr. Rai.
There is a stay of the operation of the order whereby it was directed the officer in charge of the Kansas police station to.
You are for the opposite party.
I am for the opposite party.
My learned friend is from the opposite party.
Opposite 2, Indian Corporation.
And you are for the
Petitioner.
Petitioner.
Led by. Whether, my lord, after appearance, I can, the court or the tribunal can direct for production of the petitioner in person by police self.
interim order is still?
It is still, my lord, 30%.
That was passed, my lord. If any report by the jail
4 weeks from date.
For 4 weeks. 29th March.
29th March.
No. 26th March.
No.
4 weeks.
March or February. The order was passed when? 29th of January.
January.
So 4 weeks was on February. It has long expired, Mr. Rai.
It was expired.
It expired in February. You don't have a copy of the order? Yes. File ta din.
No. Page.
This was on 29th of January, 4 weeks.
4 weeks.
It has long expired.
17th February it was rejected. It was mentioned. Now, my lord can impose the interim order on the basis of the pendency of the petition itself. My lord can decide this issue here and now, my lord. The same thing came up for consideration. After appearance, there is no occasion on the part of the commission to issue police self. For the
So I'm keeping it, I'm extending this interim order. Ashun.
No.
সাপ্লিমেন্টারি তে অর্ডারটা এক্সটেনশন হয়নি সাপ্লিমেন্টারিতে কি বললো
contesting respondent is opposite number 1.
এই স্যার এভিডেন্স সার্ভিসটা
Mr. Hallar, you are appearing for the opposite party number 2. Who is for 1?
1 has not appeared, your lordship.
on the earlier occasion this is the evidence service
1 appeared. 1 is the decree holder.
Yes.
Main fight between the petitioner
and
the
it is written with the address refused
Refused.
17,000 rupees dispute. No, it is regarding the gas connection.
It is not the
Affidavit of service filed in court today.
continuous supply of gas connection.
Affidavit of service filed in court today is taken on record. It has been submitted by Mr. Royal Honored Advocate appearing for the petitioner that in spite of service, that the registered envelope addressed to the opposite party number 1 returned with the endorsement refused, double inverted comma mode. To stop, the opposite party number 2 is represented by Mr. Haldar Honored Advocate. Full stop, the interim order.
25th 29 January 29 January 2025.
It appears from the record that an interim order was passed on 29th of January 2025, but however, the same expired in the meantime. Full stop, there shall be an order of
Last portion where your lordship was pleased to.
There shall be an order na kore korun. In the event, a report from the jail authorities has already been submitted before the district consumer forum, no further steps in terms of the said report shall be taken till the end of May 2025 or until further orders, whichever is earlier. List this matter under the heading contested application in the monthly list of May 2025. By supplementary affidavit?
Your lordship was last occasion was pleased to direct the what steps has been taken, whether I appeared before the authority or not.
Supplementary affidavit court today ekdom upore likhe deben. Supplementary affidavit filed in court today is taken on record. Have you served upon Mr. Haldar?
Pages of
Yes.
Petitioner, supplementary affidavit served. Yes, call the next matter.
Lord, I beg to appear for the petitioner. Lord, defendant is the petitioner before your lordship, my lord. The suit was decreed on compromise by filing an 151 and by a put up. But kindly come to the order include an ex parte order was passed. The decree has been recalled by a put up petition. We are not even put on notice.
When the interim order is expiring?
Lord, I tell you, lordship, Lord, what is the interim order? Kindly come to 24th December order, paragraph 8. Kindly come to 24th December order, paragraph 8. My lord, kindly have a look at it. Now the Justice Basu Chaudhary, my lord, passed an order directing parties to maintain status quo. Now what they are doing is they are proceeding with the suit in the court below. But kindly stay further proceeding of the suit. Because suit was decreed on compromise. by a 151 ex
Mr.
parte.
Chakraborty, this has come under the heading extension of
Lord, your
insurance.
lordship has the jurisdiction today. Lord, kindly, Lord, if the
Mr.
Lord,
Chakraborty,
if
I
they
have to
proceed
hear
with
the
the
matter
suit,
then.
Lord,
I am
kindly
fixed
hear,
for
Any
hearing.
day, your lordship,
kindly hear.
please,
Lord,
any day.
tomorrow,
Tomorrow,
Lord, a
I don't
decree has
have.
been passed by 151, by
1st of April,
151.
Mr. Chakraborty, I am fixing this
No,
matter.
Lord, I am a fool, I know that.
1st of
I am a
April,
fool. Lord, I am a fool, I know that. But kindly only
You don't have to say that in open court. It's all right.
2nd of April,
not only one people proceed with the suit. Let them not proceed with the suit.
strategy you are appearing
They
for.
cannot.
I'm led by Mr. Chatterjee, my
He
lord.
is for the plaintiff. He is for the plaintiff. Lord, he
And
is
you
for
are
the
for Mr.
plaintiff.
Chakraborty for
Let them
who?
not proceed with the suit.
No way.
Lord, I am for the defendant petitioner before
Mr.
Lordship. Defendant
Chakraborty, that
petitioner.
is for the
Defendant
petition.
petitioner.
Uh,
I am the defendant petitioner. Lord, kindly,
matter has
kindly stay the
ended.
suit. Lord, kindly stay the suit. Lord, otherwise, Lord,
Kindly,
Lord, entire purpose will be frustrated. Kindly stay the suit.
my lord,
Lord, kindly stay the suit, Lord.
my
If
lord,
Lord, the
the nature of
decree
the
has been recalled
order.
by a 151.
My
Lord,
lord, they
kindly
are
see the
proceeding
nature of
with
the
the suit.
impugned order.
They are,
There's no question
Lord,
of staying the suit or Milord or changing the interim order.
kindly come to the impugned
not
order once.
No, no,
Kindly
no.
come to
There's
the
no
impugned
question
order
of
once.
changing the interim order at all.
This matter has
Lord, kindly come to the impugned order once. Kindly see the impugned order. Once, just see the impugned order. Lord, by a put-up decree has been recalled without putting the
Because you
defendant on
played fraud
notice,
with court.
in whose favor the compromise has been entered into. That is to be adjudicated.
And it
That
has
is to be adjudicated, and he will proceed with the suit. They have filed application and proceeding with the suit. Let them not proceed with the suit.
Chaudhary, can I
I don't
take
mind.
this matter,
My
Mr.
lord will hear
Chatterjee?
it
Can I
later on.
take up this matter?
No, at one point of time, Mr. Bhattacharjee had appeared.
Since I'm not
Who
inclined to
appeared?
take up this matter.
Who appeared?
Shaunak.
Lord Sonak perhaps did not appear. Perhaps not Sonak appeared. Dada.
আমার সাথে
Since I'm not in.
Oh, এটা জানতাম না. My lord, I'm so sorry, my lord. I did not know this. I inquired about Mr. Aurobindo Goswami. He did not appear, my lord, in Baharumpur. I inquired
Aurobindo
about him.
Goswami has got nothing to do with my lord.
Bhattacharjee
Bhattacharjee would have
inquired.
appeared then.
Sir,
Devaki Bhattacharjee then.
সুটটা নিয়ে প্রসিড করছে ডিগ্রি রিকল করে কি হচ্ছে বুঝতেই পারছি না মানে যা নয় তাই my lord is releasing it.
আচ্ছা order dictation
My learned friends, they are joining virtually, or my lord, any of us here.
That is.
But we don't have any objection, my lord. Kindly do not release it.
Let the papers be placed before the Honorable Chief Justice for.
But they will be happy if you release it. We will be losing a good court. They will be happy.
No. Mr.
I tell you,
Chakraborty,
lordship.
say that. Yes.
all
Please
courts are
say
good.
that. Yes.
I will be missing a good court. No, they will,
All
he will be
courts are
happy.
good.
Chakraborty, please don't say those things.
Very well, my lord. As your lordship pleases.
Please, you are sufficiently senior. The
As your
position.
lordship pleases, my lord. There will be anyways.
Yes, call the next matter.
Motion, item number 8. I am for the petition. The opposite party has a plaintiff file a suit for eviction. That suit, my client made an application under Order 39 Rule 7 for appointment of the Advocate Commission. That application was rejected.
What is the suit for, Mr. Das?
For eviction. Suit for eviction.
Yes.
First position. My lord,
Why local inspection is necessary?
my lord,
What for?
my lord, in plain, my lord, come to page 9, my lord. His plaint.
Yes. You are for the defendant.
I am for the defendant. Now, plain, my lord, his claim is that the suit property is, my lord, 685 square feet.
Yes.
And two built up area such as such, kitchen, one with all rights easement, 2 bedroom flats, my lord.
Yes.
But in my lord, come to page 28, my lord.
Yes.
Page 28, paragraph 25, my lord. That the description of the suit property as described in the paragraph number 1 of the schedule of the plaint are totally wrong.
Is the page 28 is your written statement.
Yes, my lord, written statement, my lord.
Yes.
Paragraph 25A. That the description of the suit property as described in the paragraph number 1 of the schedule of the plaint are totally wrong, incorrect, and no effective degree is passed on
It's a compact flat, Mr. Das.
My lord, his claim is that it is a 580 square feet, but my case is that it is 598 square feet. His case
Nothing will happen. Compact flat,
my lord.
eviction, Mr. Das. For that,
Rather than himself hold, my lord, this plaintiff, my lord, I am placing the order, my lord, into order, my lord.
Yes. Bosun. Yes.
My lord, heard both the sides. I am of the view that it is the duty of the plaintiff to provide the proper description of the suit property in the plaint so that it can be identified without a difficulty. The plaintiff may have made some contradictory statement regarding the description of the suit property, but until it does not make any difficulty in the identifications of the suit property, that is not fatal, and the same can be cured through the necessary amendment. Therefore, again, amendment is necessary, required. Not amendment, Malad Kali, allow this appointment advocate commission. What is it paid in the page 20? Page 20, my application. Relevant page, Malad, page 22. To note down, to report about the measurement of the total flat, showing the built-up area of the flat mentions in the schedule suit property, and to note down the report about the number and measurement
So
of the.
thus, if the measurement given in the plaint is found to be not correct, suit will be dismissed.
It's not, my lord.
I'm asking you.
No.
Thank you. This application under Article 2.
I'm for the petitioner, my lord.
Yes, Mr. Das.
An application for additional party has been dismissed, rejected by the learned trial court. Suit for declaration of title, a particular share, returned by the plaintiff, and cancellation of a gift deed executed by some other persons favor of the defendant in the suit.
You are the
I'm the co-sharer of the said plot of land. I filed an application by additional party. Additional party has been
Where is
rejected.
the plaint?
My plaint is page number 22. The collusion between the plaintiff and the defendant.
Where is your application for addition of party?
It is page number 27.
27.
27.
Mr. Das, the plaintiff claims half share in the property.
Half share in the property.
And the defendant says he is the owner of the entire property.
Lordship.
So now you say you are also a co-sharer. So how that can be decided in this suit, Mr. Das?
Co-sharership.
Yes. Because even if you are allowed to be added, you will be added in the category of the defendant.
Lordship.
So can you claim a relief against the defendant? Number one, who is claiming the entire share, you cannot challenge that deed.
Yeah, the problem is, my lord.
So if you want to challenge that deed, so that deed is affecting you. So if you have a claim against the defendant number one, you file an independent suit. Why do you want yourself to be implicated?
Against a plaintiff also, my lord. He is claiming 8
You can impede both of them. But in this suit, Mr. Das, the scope of this suit is plaintiff is claiming that he is the half and the defendant number one has half share. Defendant number one says he is the owner of the entire property.
Yes.
So you cannot challenge that. That deed is staring at your face. If you have to challenge that, you have to file an independent suit against that. This application under Article 227 সাপ্লিমেন্টারি লিস্ট বার করে দিন যে yes.
My lord, at the instance of the wife challenging an order of alimony pendentiality under section 36 of the Special Marriage Act.
Yes.
My lord, only 6,000 rupees has been given, considering the fact that the wife, present petitioner, is a BSc honors in chemistry. My lord, she is not employed, and she is only getting 4,000 rupees as interim alimony, interim maintenance under section 125. Considering these two aspects, learned judge has given this amount, but the opposite party husband is earning much. My lord, I am praying for issuance of notice, and if any, in the meantime, if a little bit of increase.
In the meantime, no little bit of increase.
No.
None appears for the petitioner at the time of call. No accommodation has been sought for.
For the petitioner, my lord. Under order 21, rule 101, application was rejected by the impugned order, my lord, in the.
Order 21, rule 101. How 227 is maintainable? How 227 is maintainable? It's a deemed degree.
My lord. My lord, liberty to press, my lord. Liberty to press for.
Rule 103. When an application has been adjudicated upon rule 98 or rule 100, the order made therein shall have the same force and subject to the same conditions as to an appeal, otherwise as it was a decree.
Liberty
Not checked up prior to filing this division. Ashun, by the order impugned, the
Second, my lord, I am for the petitioner, led by Mr. Tanmay Mukherjee, kindly praying for a short passover, my lord.
Please start, please start.
My lord, I am for the opposite party, led by Mr. Aniruddha Chatterjee. Mr. Chatterjee is appearing online, my lord.
I picked okay.
Yes, Mr. Chatterjee.
Opposite party, my lord.
So, yes, you have nothing to say.
right now.
Yes.
My lord, your lordship will find, my lord, this, I don't know what Mr. Mukherjee is going to submit, but then a will is not a transfer. He has challenged, my lord, the
But
maintainability.
before Mr. Chatterjee starts, I think Mr. Chatterjee once appeared in this for my
For your client. Yes, Mr. Chatterjee.
My-
Now you are in difficulty, not the court. You appear for the petitioner. So I'm appointing you as an amicus, Mr. Chatterjee.
on behalf of my mother on this same suit prop.
On behalf of the mother of the petitioner.
This is mother, my lord.
So you act as an amicus, Mr. Chatterjee.
No, no. But allow me to take instruction, my lord.
Both the parties have faith in you. Both have engaged at different points of time to have engaged you. So
If I may request my learned friend, my lord, to just let me know the details. I'll talk to him, my lord, today. Keeps it tomorrow then. Keeps it tomorrow. My lord, it's happened to me many times. I don't want to go to the bar council anymore. Kindly keeps it tomorrow. I will, my lord, talk to him.
I didn't find the name of Mr. Chatterjee appearing in the order sheet, my lord. I have checked up, my lord.
What
the
is
suit.
this?
Mr. Dash, allow me to find out kindly.
This is for his mother.
My lord, that matter. I'm on that matter.
With Mr. Sudhis Dasgupta.
But
with
my lord,
Mr.
there is
Sudhis
no
Dasgupta.
reflection in the order sheet.
That is up to Mr. Chatterjee whether to
Allow me to find out, Mr. Das. Relax. Let me find out what it is.
When this
One party.
opposite party pays for an accommodation to take
The petitioner has paid for an accommodation.
Mr. Chatterjee for this, his prayer was rejected. It's now on your prayer. So he was about to start. Then he made this first submission. Mr. Chatterjee, honored senior advocate, appealing for the opposite party, prays for an accommodation to take further instructions from his client. I'm putting it at that. List this matter tomorrow under the heading motion. Yes, next.
My lord, it will appear in the listed motion or motion under the heading.
We will get it in the server today in the evening.
Grateful.
Yes.
My lord, 14, I appear for the petitioner, your lordship.
Yes.
Yes. My lord, the petitioner before you, there is a suit for eviction, your lordship. Petitioner is a defendant. My lord, the suit was decreed.
You are for the judgment debtor.
I am for the judgment debtor.
Yes,
And
what happened?
Suit was decreed against me, I was evicted.
You was decree for eviction passed or you have been evicted?
Yes, evicted. Thereafter, an execution petition was filed against me.
Yes.
My lord, in the execution petition, my lord, there was an error under Order 21, Rule 24(3), which was held by the trial court to have been, my lord, summons issued defectively, for which, my lord, the trial court directed, my lord, for return of the possession of the, my lord, premises. Because the possession had been handed over wrongfully. It was held. And my lord, there were further
impugned order.
My lord, impugned order, your lordship, at page 90.
Yes, what is the
impugned order? Nature of the impugned order is that, my lord, in the meantime, wherein, my lord, the Landlord trial court had held the possession to have been handed over improperly, irregularly, hold it to be irregular, my lord, they have transferred the spare parts and machineries out of the property, thrown me, evicted me of the property. I complain, my lord, under, my lord, section 12 of the Contempt of Court Act, that during the pendency of the order for injunction, status quo injunction, my lord, all the spare parts and machineries have been, my lord, third party encumbrance created. I complained that to the Landlord trial court. The Landlord trial court at page 90, the impugned order had rejected it on the ground that, my lord, there was a my lord, civil revision pending from the order of civil revision pending before this Honorable High Court, my lord, challenging, my lord, the order wherein the trial court had held the return of the handing over of the possession to be irregular, and, my lord, there was a title suit filed by me against the, my lord, order of eviction, the decree passed. During the holding that the pendency of the two petitions before the Honorable Trial Court, my lord, my lord, rejected my application under honor for section 151, read with, my lord, section 12 of the Contempt of Courts Act. My lord, I am of the, my lord, view, my lord, before your lordship, I am praying that, my lord, the learned trial court ought not to have rejected it. At most, my lord, could have, my lord, referred it to the Honorable High Court for its, my lord, to take cognizance of the matter.
What is the date of the order?
My lord, the date of the order, your lordship, 15th of January 2025.
15th of January.
January at page 90, your lordship will find that.
Have you challenged the decree?
Yes, my lord, I have challenged the decree.
What happened to that?
My lord, that is pending. No order has been passed. That
No
is
order of stay.
No order of stay before this honorable court. That is passed. That is pending. No order of stay. My lord, they preferred a civil revision against the order.
Before this court, why?
My lord, yes, before this court. My lord, it's a civil judge senior division.
Yes. What is the valuation?
My lord, valuation. My lord, the valuation is, my lord, 1,50,100.
So you moved the application for stay? No.
Before this honorable court, my lord, that I am not aware of. I am not briefed in that matter. But my lord, I am told that no stay order has been passed.
Complied with the decree for payment of mean profits?
My lord, that was that my lord, I am instructed that was not made. That is also reflected from the order itself.
You have also violated the order.
My lord, that was the main order of eviction, your lordship. Thereafter,
there is no stay.
There is no stay.
So you have also to comply with that.
Well, I did not comply with that. I was thrown out. I was thrown out, an execution petition for that, my lord. My lord,
throwing out is not only because you are liable to pay mean profits also.
My lord, absolutely. For
There is
that
no stay.
For that they have filed the execution. My lord, execution includes both, my lord, my lord, throwing me out of the property, as well as for, my lord, collection of the mean profit. For both, my lord, during the execution petition, my lord, the trial court held that, my lord, the possession was returned to them in a most irregular and unlawful manner, for which, my lord, that your lordship will find. Your lordship kindly sees that order dated, my lord, 5th of August 2021 at page 82.
Milord, I appear on behalf of the petitioner.
Although
Milord, generally, Milord, all show cause petitions get allowed.
although there is no
model
before,
to that
before
proposition.
my friend commences, my lord, although there is no caveat, I have come to understand from the learned trial court that I have been incorporated as opposite party in this petition, in this revisional application. My lord,
What happened?
Milord, now, Milord, a show cause was issued by the learned trial judge.
Now, my lord, a show cause petition was filed by the opposite party. The question is, my lord, who filed? My lord, that's why, my lord, I am saying.
So you did not take steps. So you are directed to show cause.
Not me.
It is alleged that I have not
My
taken
lord,
steps.
he has not taken steps.
Oh, he has not taken steps, he was directed to show cause.
Yes.
So he has shown cause, but who has shown cause, that is the dispute.
Yes.
For that, the show cause was rejected.
No, show cause was allowed with a observation that the learned trial judge doesn't want to go into the hyper technical issue. My lord, I understand, my lord. I understand, my lord. I am not into that. My lord, who filed? What was the contents? No verification, no signature, nothing. My lord, if this gets allowed, my lord, there is the difficulty. My lord, show cause petitions gets allowed. My lord, I'm submitting it. But my lord, some checks and balances has to be there.
I appreciate your submission, but if it is again remanded, he will file a fresh application.
My lord,
What is the nature of the suit?
My lord, matrimonial dispute, I am the wife.
Nature of the application that is coming up again.
My lord, he is not on caveat, my lord. I will serve him a copy, but my lord, for this purpose only. My lord, let that be remanded within a fixed period of time. My lord, if for 15 days maximum, my lord, or that observation
accepted, I'm expediting the suit.
My lord, that observation.
I'm expediting the suit.
That observation has to go. My lord, that is my
what observation?
My lord, kindly see, my lord, the impugned order.
But this is not
Order
on the
dated. This is on a miss case, a 340
miscase,
proceedings. My lord, that's why the high voltage contest, stating that I have misled the court, 340 proceedings is pending against me. In that 340 proceedings, my lord, in that miss case. That is the, my lord, that's why, my lord, this high voltage, my lord, thing. But, my lord, kindly appreciate one thing, my lord, who filed, my lord, that is, my lord, kindly come to, my lord, page.
Sir, if you want that,
122.
it can be
page 122. My lord, kindly comes to my lord.
122.
122 is the show cause order, and my lord, thereafter 122 show cause order 10th November 2022, show cause upon the petitioner. Show cause upon the petitioner.
No, order number.
My lord, 10. My lord, this is the initial order of show cause. This is not under challenge. 10th November 2022, page 122.
Yes, Arun files a petition praying for stay objection.
Well, a later part of the later order, yes.
Filed
This case 176 of 2020.
But the learned advocate on behalf of the petitioner, none moved. Issue show cause upon the petitioner shall not be dismissed for default.
Yes. Well, show cause upon
case. The miscase will not be dismissed for default.
Show cause upon the petitioner. Now, my lord, come to page 124. My lord, this is the show cause petition. My lord, see who has affirmed it. Neither affirmed, verified. Todbit card, my lord, no connection, my lord, nothing, no signature, my lord. And how these statements can be true to this Todbit card?
Maybe a copy, the signature was there in the.
No, my lord, there is nothing. And my lord, kindly see the contents. Paragraph number 3.
It's whose suit? Your suit.
My lord, the miscase is by them.
I'm asking you, suit is whose suit?
My lord, suit is also by them.
Wife's suit?
No, I am the wife.
You are the wife?
Yes.
Suit?
Lord,
what is the miscase for?
My lord, initially, my lord, there was an order of maintenance.
340.
Yes. So, my lord,
why 340?
Documents are there, which has been produced.
Then,
confronted.
If you insist on 340, then this also has to go.
But,
if you insist for 340, then this also has to go. All right.
But then kindly allows me to come back tomorrow with the instructions.
I'm directing.
My lord, praying for Passover.
An accommodation has been paid on the ground of the learned advocate for the petitioner. Such prayer is allowed. Hearing of the matter stands adjourned.
Praying for release, Mr. Bhattacharya is.
Since I'm not inclined to take up this matter on personal ground, this matter stands released from the list of this bench. Let the papers be.
My lord, in item number 18, I appear on behalf of the petitioner, my lord. The petitioner is the opposite party in an application for revocation of probate, my lord.
Yes.
My lord, my application for recalling has been rejected, my lord. My lord, kindly
Your
see
application for
recalling of an order, my lord.
what order?
My lord, kindly sees page number, running page number 26, order number 19 of
Yes.
9th of January, my
The
lord.
recalling of what order has been rejected?
My lord, the cross-examination has been closed, my lord. My lord, there,
You prayed for recalling of that.
my lord, there has been a miscommunication, my lord, that the reason for which the cross-examination has been closed.
Why it was closed?
There has been a miscommunication between the law clerk and the advocate, my lord.
So you did not cross-examine
My lord, kindly allows.
by the order impugned. The
My lord, in item number 19, my lord, I appear on behalf of the petitioner.
19 you are appearing. Yes.
Saying for release of the matter, my lord.
Release. Why?
My lord, because the Ronak Bhattacharya
Ashun.
member.
Since I'm
My lord, I'm praying for a short Passover in this matter, my lord.
Why, Mr. Chaudhary?
Being led by Mr. Probal Mukherjee. Yes.
What is this matter?
My lord, I am a purchaser of a portion of a property, my lord.
Yes.
At
Yes.
I had filed an application under Order 21 and Rule 97. There was a partition suit between the co-sharers. I purchased from one of the co-sharers, and in the decree it was held that my portion of the property should was not decreed. The purchase by my predecessor in interest was held to be sacrosanct. Correct purchase. From that purchaser, my predecessor purchased from one Fateh 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 Noor had transferred a portion to another gentleman from whom I had purchased. Now, my lord, while I was enjoying the property, Some people come and they come with an order that I have encroached on his property. Now, my lord, then I approached the learned court. I made inquiries. I approached the learned court. I filed an application under Order 21, Rule 97, my lord. In those proceedings, my lord, I filed 2 applications.
Yes.
The first application.
What is the interim order? You wanted, what is the order
impugned
under
order-
challenge?
Yes.
15th of
Impugned order, my
February.
lord, my 2 applications by which I wanted to put on evidence, take on evidence a deed of 1967, which my predecessor in interest had purchased.
Yes.
I wanted to bring that out record because I did not have, I did not get the opportunity. The learned judge, court below, my lord, if my lord comes to page 246, that is the impugned order.
Yes.
An order of 15th February 20.
Where is Mr. Mukherjee?
My lord, Mr. Mukherjee is, I am also being led by Mr. Sanjay Mukherjee also.
My lord, this is
Impugned order.
Order 21, Rule 97. I am the petitioner in the Learned Trial Court and Learned Executing Court. In that executing court, my case is that I am not bound by the decree passed in the partition suit. On the ground that the property which has been made part of the partition decree, partition suit hotspot, has been already purchased by me from my vendor much prior to the partition suit instituted. And after that,
But your vendor purchased from a co-sharer.
vendor purchased from a co-sharer,
His shares were declared.
entire share of that co-sharer had been purchased by my
Yes. So that original co-sharer's share has been declared in the partition suit.
No. There I am joining the issue, my lord. While passing the judgment of the final preliminary decree, that deed was challenged by the son of the my vendor's vendor. Learned Trial Court had upheld that the judgment, that deed is valid, and that particular portion could not be part of the partition suit hotspot. Excluded. While
Why? Because he was a co-sharer.
but since it is already sold,
Maybe.
Learned
But if an undivided part has been sold, so how can it be brought out of the hotspot? Has to be within the partition suit.
But the thing is that
because it's not a case of a common owner transferring by way of demarcation.
No.
If one of the co-sharers has transferred, so it's an undivided portion. How can it be brought out of the purview of the partition suit?
Learned Trial Court.
What happened? What is the impugned order?
After that, Learned First Appellate, Learned Trial Court, while passing the final decree, had included that property. Now, in the preliminary decree, it is not there. In the final decree, it is there.
Final decree, your allotment has been made.
No, I am not there. I am not party because
your predecessor might be a party.
My predecessor has been party.
So you will be getting that share. What is the difficulty?
No. The difficulty is the partition commissioner has allotted that part of the property upon which I have already made constructions and there is a mall standing.
No, I could not follow this.
The
partition commissioner
has allotted that part to the decree holder's share upon which I have already.
Decree holders means
the decree holder, the plaintiff decree holder.
Yes.
Share a part of the property of 6 decimal upon which my entire purchase is 1.31 acres, 85 decimal from my vendor. 6 decimal has been made part of that, upon which I have already made constructions in 2006.
Who has made construction?
I have made construction upon purchase because I am not aware of that suit.
Yes.
And now,
but it has been allotted to the
decree holder.
To the decree holder.
What has happened? I file order 21. I file order 21, rule 97/101. And in that proceedings, I seek to adduce that deed of 1967 as an evidence in which my vendor had purchased. That has been marked as exhibit X and X-1, the English translation is X-1. On the ground
that these deeds have already been marked exhibit in the original partition suit. It cannot be marked again in the executing court. Disregarding that Order 2197 is akin to a separate suit. Everything can be adduced there. Then I file an application that the partition suit of 48 of 1994 be brought on record so that I can show. Learned executing court dismisses both the applications by the impugned order. That's why I am before Lordship.
Show me the impugned order.
I should kindly seize the impugned order. My lord, I am led by Mr. Probal Mukherjee. He is in another matter on his legs, my matter only. Lordship kindly keeps it, short passover or anything, he do and come back.
Passover.
No, passover.
Yes.
I'm obliged, madam.
Lordship, this is an application for expeditious disposal, Lordship.
What?
Of an Act 8 case filed by the father, Lordship, in the year 2022. The father was removed from his the child was removed from the father's custody in the year 2019. Thereafter, in the year 2022, the father has filed this Act 8 application under Section 25 along with connected application. See, till date,
The interrogatory applications are pending or disposed of.
till date it is pending, Lordship.
Interrogatory applications
Yes,
are
Lordship,
pending.
like Section 12 application.
This application on Article 227 of the Constitution of India is
My lord, in item. My lord,
Yes.
I beg to appear on behalf of the petitioner, my lord, in item 22.
22.
My lord. 22. My lord, matrimonial suit for divorce filed by the husband. Then it was withdrawal by the husband after passing of an order under Section 24, my lord, without paying me any maintenance.
Yes.
My lord, I am aggrieved by that. My lord, the last page of the certified copy is the order impugned.
But now the suit has been dismissed for non-prosecution.
My lord.
So, how 227 is maintainable?
My lord, under Order 23, Rule 1.
Yes.
My lord, appeal is not maintainable, my lord. That is why I am before your lordship.
No, the suit has been dismissed for non-prosecution. The entire
My
suit
lord.
has been dismissed.
My lord.
Yes.
My lord, the suit has been dismissed, but
yes,
I also did a bit of research in this issue.
You
My
are
lord,
for
the
the,
appeal from
you are for the defendant in the suit.
my lord. I am the defendant wife.
Dismiss for non-prosecution is dismissed for default. It has to be restored.
My lord, dismissed for he has withdrawn the suit.
No,
He
no,
has
no. There is no order of withdrawal.
My lord, that is there. I have annexed the
He
petition
says
of
he
the
is not
withdrawal.
interested to proceed.
My lord, yes, my lord, I have also annexed the petition filed by the husband for withdrawal
Dismissal
of the
of the
same.
suit.
My lord,
Prays for dismissal of the suit. So the suit is dismissed.
my lord, this suit was. May I place the order? May I pay? My lord, kindly peruse the running page 30. 30 of my petition, my lord. The petition filed by the husband. He has filed an petition under order 23 rule 1. My lord, page 30 of my petition. The withdrawal is under order 23 rule 1 minus, subject to correction.
But it's not withdrawal.
My lord, kindly seize the withdrawal petition, my lord. Page 30 of my.
But order is not withdrawal.
Well, I am
Order is
aggrieved by that. That too.
That is the difficulty.
My lord, that too, after passing of the order under section 24.
You ought to have objected at that time. Where were you?
I have raised my objection, but
Where is your objection being raised?
My lord, I
Does
have
not
not
appear
given
that
it.
you have raised objection.
My lord, I
Heard
have
both
not.
sides. Your objection has not been recorded. You ought to have recorded an objection that it cannot be
My lord, kindly seize
withdrawn
the
prior
impugned
to
orders, my
deciding
lord.
my application under section 24.
My lord, kindly see application under section 24 was disposed of.
Yes.
Disposed of, but he didn't pay any money. Then the matter issue.
For that you have other remedies. For that you have other remedies.
My lord,
An
they
order
are
has
not.
been passed, but not complied with. You have other remedies. For that you cannot compel the other side to proceed with the suit.
No, my lord, certainly not. Certainly not.
So
My
now
prayer.
Other remedies.
My lord,
If
my
your
lord.
allegation is that an order of alimony has been passed, not complied with, you have other remedies. Invoke those provisions.
My lord, the difficulty is
that order.
As the suit is no more there, they are not allowing me to file any execution as well.
Where is that? It does
My
not
lord, they
appear
are
from
not
here.
allowing me to file.
No,
I have
no.
pleaded, my lord. I have pleaded.
Maybe it cannot be that you cannot file an execution. Who says all orders are executable orders? How can you say that?
My lord, may I place my case, my lord? My lord, it was sent first in the mediation, my lord. It was failed.
I can only adjourn this. You can try your luck to file an appropriate application for execution. You have not taken appropriate steps for filing execution.
Malik, kindly order one line of that. Kindly, madam. May I serve?
That
may I serve and come back?
No, you did not serve. The learned advocate appearing for the petitioner submits that since the suit has been withdrawn, the petitioner is not being allowed to execute the order of alimony passed by the learned trial judge. First up, however, the learned advocate for the petitioner prayed for an accommodation to take further instructions in this regard. List is matter in the monthly list of April 2025.
My lord, liberty to file execution. My lord, liberty to file execution.
No liberty is necessary. You said you could not have recorded your submission. Please file execution.
My lord,
Not that the execution case you are not being allowed to file. No
Grateful,
liberty
my
is necessary for that.
lord.
Motion.
Grateful.
Yes, call the next.
But the impugned order, my lord, the learned court below, my lord, rejected my prayer for, my lord, using the secondary evidence. But although all ingredients have been, my lord, complied with, when, my lord, the cross-examination of the plaintiff, my lord, was adduced. My lord, this is suit for eviction of a trespasser.
What is the secondary evidence you want to
My lord, that
produce?
is the affidavit, my lord, affirmed before executive magistrate that was notarized in presence of the, my lord, the plaintiff petitioner. He, my lord, adduced evidence before the learned court below that I have seen, I have compared with the original. And
Where is that evidence?
my lord, kindly have a look to page 50, my lord.
Page
50.
50.
My lord.
Give me a minute.
My lord. At the top, my lord.
Why photocopy of the affidavit?
My
Where
lord,
is the
that is
original?
lying with the defendant. My lord, I paid for inventory. That was also rejected. My lord, it is, my lord, lying in the suit property. My lord, at the, my lord, the custody and control of the defendant in the, my lord, Almira. Well, I have no access to that document. That's why, my lord, I also paid for inventory. That was also, my lord, rejected. And this is, my lord, the vital document because, my lord, my adoption has been challenged. My adoptive parents were the owners of the property. My lord, I inherited that property. I filed a suit for my lord, trespassing into the suit property, and that documents, my lord, has not been considered.
Where have you stated that the original is lying in their custody?
My lord, in the application, my lord, kindly have a look to the, my lord.
No, in the affidavit in chief. Show me that application.
My lord, in first of all, my lord, it was, my lord, not marked and exhibited. My lord, it was produced before the landed court below. My lord,
according to you, the original affidavit is not in your possession. It is lying in the custody of the other side.
Dependent.
So for that, prior to bringing secondary evidence, some steps are required to be followed.
Yes, my lord.
Have you followed those
I
steps?
filed that application, my lord. I filed that
That is not
application.
sufficient. That is not sufficient.
No, my lord,
Other procedures are to be followed.
well, I filed that application. I paid for inventory that let the officer be appointed so that he can make inventory of the.
What inventory?
Well, that is lying. The documents is lying with the, my lord, the defendant.
Show me that you have stated that the document is lying in that custody.
Well,
and what steps have you taken?
Well,
I think there is provisions in the Evidence Act that you have to take steps for such. If you say its original is lying in the custody of the other side.
Page 97, ma'am. Page 97, ma'am.
Page
That is
90.
the earlier order, 97, ma'am.
Not the earlier order. Show me from your evidence. Chakravarti, if you are not ready, you can come prepared on that.
No. Well, then I'll come back tomorrow. Madam.
An accommodation has been paid for by the learned advocate for the petition.
My lord, before my lord calls the next item number, my lord, in item number 23, my lord kept it for tomorrow, my lord.
Item number 23. What happened?
20, again matter.
Adjourned. Yes. Next.
Lordship, item number 24 and 25. Both are suit for money suit for recovery of money. Plaintiffs are same. I'm only praying for expeditious hearing. Why? Suit of 2017, the defendants appear in 2022 and till date, the date is being fixed for filing return statement. And the irony is the learned trial judge is writing to file return statement within statutory period for last 5 years. But you would kindly see. The order or last order dated 26, 11th February 25. Next date is in May. Since 2017, dates are being put on to be filed by WS. Moreover, defendant number 1 has filed WS outside the time. No application for acceptance of such WS has been filed. It is kept with the record and the suit is being pending. No progress whatsoever in the suit for since 2017, Lordship. Two different suits, but similar parties, similar relief.
Ashwin. The learned advocate appearing for ম্যাটারটা দিন।
Money suit number
Only
528.
the money suit number will change. Order date is same.
Same, everything
Same money suit number.
everything. Only the one of the name of the defendant and the number of
Yes, next.
much.
Yes, Mr. Banerjee.
Note, my lord, that section 7(1) application is onerous liability of the tenant. 7(1) is the onerous liability of the tenant to deposit admitted rent and admitted area, for which no determination is called for by the court.
It's a no dispute situation.
Yes, no dispute situation. Now, my lord, your lordship kindly look to
What
the
happened?
impugned order. I never got astonished, my lord. That is why 2 orders I have challenged.
You are the landlord.
I am the landlord. এটা কত নেবে? এই
Mr. Banerjee, it's really an adjudication under 7(2) has been made.
No, 7(2) is separately.
But
Because
really,
adjudicate-
nothing
no,
is left in
no,
7(2).
No, he has left, my lord.
What?
Because according to him, my lord, that admitted area and admitted and rate of rent is 230.
Yes.
He has
What is your
deposited-
claim?
My claim is 240. Area is also different. Therefore, it is not a substance.
No, yes,
7(2).
that is why he was directed to deposit.
230.
This could not have been done under 7(1). Mr. Banerjee, according to you, the rate is 240. According to you, rate is 240?
Determination is to be made.
Yes,
at
yes.
7(2).
According to you, the rate is 240 rent.
240.
And period of default,
Period
according
of
to you,
default, according to the
you,
trend, the period of default is
33 months.
no more than that.
All right. So,
According to the print averment, your lordship kindly come to at page 16.
yes. Tell me the period.
কবে থেকে গো? May 2022.
May 2022. So, how many?
May 2022.
And this suit was filed in 2024. So it's almost 33 months, Mr.
7(1) was disposed of by order number 12. Kindly look to.
Yes, yes. No, Mr. Banerjee. So what is the period? It will be 33 months. I think 33 months.
30. How determination, my lord? Practically, there is no scope for determination. There is no scope to question is, my lord, 7(1). No.
Banerjee.
Lord, my submission is 7(1) is to deposit. Only deposit. Challan is to be filed. And challan is to be passed so that he can deposit. No scope, my lord, for the purpose of filing 7(1) for determination.
I appreciate your submission.
No. Then 7(2).
Yes.
7(2) is not maintainable because he did not comply with 7(1). Number 2, my lord. 7(1), the court directed him to deposit practically 1 year after. 1 year after, my lord, he was directed to deposit. That he cannot. This 1 year period extension, court has got no jurisdiction. Section 5 will not apply. No jurisdiction. Lord, this is the only point.
But Mr. Banerjee, what is your suit for?
Suit for eviction on the ground of default and reasonable requirement. No, 7(1), my lord. 7(1) he can.
I appreciate everything, but your suit will get stayed. That is the difficulty.
Lord, let it be a state. I shall give a notice. Let it appear as listed motion. It is a short point.
All matters are short points.
Very short point, my lord.
By the Yes,
Not-
call the next matter.
Next, same matter.
Next is same.
Same in matter. We have two tenants.
So suit number will only change.
Suit number will only change.
Suit number to bolini na suit number ta আছে state ate. সেটা দেখে নিন।
Suit number will be changed.
Same order. Yes,
Same
next.
order. Lord, your lordship appeared before Home Justice Ashish Chakraborty.
In what?
That is 7-1. That owner has liability. It is your lordship's argument. 7-2 is liable to be dismissed. And mandatory, there is no scope for the purpose
After
of-
the change from
After the-
56 to
after
97.
change, after change.
So I argued that matter.
But I think, my lord, on that point, my lord, I got a judgment of the 3 judges bench, my lord, that section 5 is not applicable because of section 40, even not with a
I have considered that.
But, my lord, 3 judges bench was not considered. I will argue before a single bench. If
So according to you, section 5 is applicable.
applicable. So as far as
Judges bench of what?
3 judges bench with regard to 17(2) B. Their language
Mr.
is
Banerjee,
same.
those
Language
were
is
considered by the Honorable Supreme Court in Devashish Pal's judgment.
But
Exhaustive points considering the provisions of section 17 of the 56 Act and 97 Act.
But, my lord, 3 judges bench, lord, judgment was not considered. Their section 39 was interpreted.
But yes, I think I have considered in one of my judgment.
79
In
Supreme Court.
I think the Costa at least Parvati Charan Rockety. Please consider that. I have considered that those larger bench judgments.
Lordship. Because in view of the judgment of the Supreme Court, section 5 is not maintainable.
But those were considered because now there is a shift in the change. 17(1), 17(2) and 7 is completely different. There was a provision for extension of time in 17, which is not there. Only
And
one.
17(2)A was also there.
That is the difficulty.
And Nasiruddin, my lord, Nasiruddin gave clear everything with regard to that
And
point.
the latest judgment of the Supreme Court is of Devashish Pal. It took
Devashish
into
Pal.
consideration all.
Yes.
Section 40 also I have considered.
Also
Mr.
considered.
Aniruddha Chatterjee argued in that. And I think the larger bench, 3 judges bench was also considered by me.
Yes, yes.
Kindly check up.
Yes, lordship. I will take.
Yes, next.
Yes.
Lordship, I am for the petitioner wife. I'm led by Mr. Prosenjit Mukherjee.
Yes.
He is on his way. And this matter is the impugned order dated 14th January 2025. The miscase under section 24 of Hindu Marriage Act has been dismissed for default while the petitioner's advocate was present there.
Dismiss for default, you have to file an appropriate application for restoration. How 227 is maintainable?
Lordship, it is under section 24 of Hindu Marriage Act.
But the matrimonial suit has also been disposed of. This miscase is in connection with that. That miscase is for section 24. That is alimony pendent ilite. If the main proceeding is not there, what will happen with the miscase? That has to automatically go.
Lordship, I'm praying for some
An accommodation has been paid for on the ground of the learned advocate for the petitioner. Such prayer is allowed. Hearing of the matter. Yes.
Petitioner is a labor cooperative society, my lord. And all the members are the laborer and engaged by the Indian Oil Corporation, their regional office for canteen services. That is washing utensils, cooking, servicing, everything, my lord. So there is no item of doubt. Their legal status is the employees, my
Which
lord.
order is under challenge?
My lord,
What is the date of the order which is under challenge?
my lord,
6th of March.
my lord.
What happened?
Only point I should draw your lordships. This is, oh, sir. 126 number.
Page 117 page, my lord, kindly look into 117, page 117.
Page 117, yes.
Of which, my lord, review application was rejected. Originally, my lord, the court has.
If the review application has been rejected, parent order has to be challenged.
The parent order, both order has been challenged.
Both are.
Yes.
Question is, my lord, they are not the, they are the cooperative society, they are the employee. The principal employer has been, my lord, they have been engaged by the Indian Oil Corporation for rendering service as a cooperative society. All the members are employee of the corporation, not the corporation. They have formed a cooperative. Their remuneration is paid through the cooperative society. The society is, my lord, disbursing the amount to the society has no fund, and the
So you are challenging the order of injunction.
challenging the order of injunction by virtue of which, my lord, the remission has.
So you
got-
serve a copy.
Yes, my lord. And in the meantime, my lord,
Stay.
there has been a direction for payment of the. My lord, we can't be, my lord. This is
Pay that amount.
My lord.
My lord, we have no fund.
My lord.
And
Uh,
Mildly, my lord, kindly hear, my lord, because all there are laborer, my lord.
Yes, yes. So they have to be hard.
My lord, because already, my lord.
An order of 2023 without hearing, it cannot be stayed.
My lord, their bank account will be attached, and my lord, they will not get their.
It's an order of 2023. Please serve by the order.
My lord, they will not get the salary, my lord. They will not get the wages, my lord.
From 2023, Mr. Mitro, if the stay is granted at the admission stage, what remains in the final
My
year?
lord,
That is the ultimate relief you are saying.
they are right.
A short date be fixed in the meantime, my lord. We will.
No coercive step might
Yes,
be
yes.
taken
Call
by
the
the
next-
corporation, my lord.
Call the next matter. Yes.
Order, my lord. Just protection, my lord. One line order of protection, my lord. Because they.
Then I have to give my reasons for refusal. Then I have to give my reasons for refusal. Cannot be. Mr. Mitro has understood.
Section 2B, have a look at the section.
So the ultimate relief, can it be granted at the admission stage? You will be getting that relief at the final stage.
But their way, my lord, if the bank attached, my lord, every time their.
Nothing will happen from 2023, this order is there. Nothing will happen.
And that is the next 31st of this month, my lord. Their salary, their wages date, my lord.
From 2023, this order is remaining. Yes, next.
I put the petition on lordship. Matter be placed in the monthly list of April, my lord.
April, all right, April kore din. Yes, next.
I am for the petition of lordship.
Yes.
Petitioner come before your lordship challenging the order passed by of Learned Court
What order, please? Huh?
dated 30 January 2025. The certified copy of the order is annexed at last page 28 to 29. The petitioner could not get file the written statement. Kindly see the lordship impugned order.
Why did not file your written statement?
Lordship, the copy of not supplied to the defendant by the plaintiff, under which the plaintiff relied.
It was not supplied.
Lordship,
How could you annex this page 14 plaint?
Lordship, Lordship, kindly see the plaint.
Yes. This copy was supplied to you.
Page 15, Lordship. Photocopy of the said lead license agreement is annexed here. That document is not handed over to us, Lordship. Plaintiff not complied the provision of Order 7, Rule 14, Lordship. It is a Learned Court also not petitioner applied 3 applications on 3 different dates. That application was not disposed of by the Learned Court without issuing an order of show cause past ex parte hearing. Three-time petition made.
When did you appear?
Lordship, petitioner appeared on the
23rd of April 2023.
Lordship.
When did you file an application stating that the copy of the plaint was not served?
23rd.
Show me that application.
2023.
Show me that application.
Lordship, this is the page number 23, Lordship.
Page number 23.
Lordship.
It was filed on 12th of April 2023.
12 April. Thereafter, 2 applications was made. That was not disposed of. Without issuing any order of show cause. Please to Learned Court, please to pass an order of ex parte hearing. And petitioner preferred application to Order 9, Rule 7. That was also dismissed. That application is still remaining pending, Lordship. Key application.
Where are the annexures in the plaint?
Lordship, I'm sorry.
What are the documents which have been annexed with the plaint?
Plaintiff annex, page number 15, Lordship. At the bottom portion, a photocopy of the lead license agreement is annexed here with marked as Annexure B. That annexure is not supplied. As such, the plaintiff not complied the provision of Order 7, Rule 14, Lordship.
By the order impugned, the prayer of the petitioner to set aside the order fixing the suit for ex parte hearing stood rejected. First up, the learned advocate appearing for the petitioner submits that the documents which were annexed to the plaint were not served along with the summons, and in spite of the fact that applications were filed by the petitioner praying for a direction upon the plaintiff to serve the copy of the such documents, those applications are still pending. Petitioner is directed to serve a copy of this application upon the opposite parties by register speed post with acknowledgement due and file an affidavit of service on the next date. List this matter under the heading contested application in the monthly list of May 2025.
In the meantime, one stay.
There shall be an order of stay of all further proceedings of the suit pending before such and such. Suit number such and such.
Get till
the end of June 2025 or until further orders, whichever is all here. Yes, next.
Well, for expeditious hearing of the partition suit, my lord. My lord, partition was filed.
22 suit.
My lord, kindly see, my lord, injunction petition was filed in.
All suits of the year 2022 has been disposed of.
No, my lord.
It's the only suit pending.
No, my lord. Kindly see, my lord, the ad interim order was passed on 22nd May, my lord, 2022. Thereafter, my lord, the injunction petition is hearing, my lord, is not done, my lord. Though, my lord,
Injunction application is still pending.
yes, my lord.
I'm
My lord,
directing the, what is
kindly
the,
see the order of 18/7/2023, my lord. WO filed by the 123, that was, my lord, the defendant filed, my lord, WO. Defendant number 4 didn't file, and for 5 to 7, they against them the ex parte order passed. Even then, my lord, the next date was fixed in, my lord, 12/9/2024.
written statement has also not been filed.
No, my lord. My lord, 3 years.
All the defendants have been served.
Yes, my lord.
Why SR? For whom?
Well, kindly see 18/7/2023.
Last order, 12th of September 2024.
That,
Why it has been fixed for SR? Upon whom?
But my lord, kindly see 18/7/2023. Everyone is served 18/7/2023.
This application under Article 227 of if the same is otherwise ready for hearing.
This is my application, my London Session 24 of the for transfer of the suit from Navadvip Court to Rampurhat Court. Since the wife petitioner is residing at Nolhati and the distance from Nolhati.
Written statement filed.
Yes, my lord.
You have filed.
Yes. Yes, filed, my lord.
Issues framed.
No. Stage of conciliation or something.
Conciliation.
Like that.
Appear for the conciliation. It might be reconciled.
No, not yet fixed, my lord. Only for the
It will be fixed very shortly. Appear for reconciliation. The parties may settle their differences.
has been filed.
Yes. After that,
no date has been fixed.
It will be fixed very shortly.
But I am because there are other cases pending in the Rampurhat Court also, my lord.
Other cases, criminal cases.
Criminal cases
Filed by you.
Filed by me, so that that has been husband has been
Go
attending.
to the husband's place to contest the matrimonial suit. Husband will come to your place to contest the criminal cases. This application under Section 20.
Plaintiff petitioner application for expeditious disposal, my suit of declaration of permanent injunction, my application for appointment of a receiver is kept pending since 2020. Now it is fixed for, it has been heard, part heard, and the next date is on 28th for hearing, for further hearing.
28th of March
March
or April.
March for further hearing.
This application under Article 227 of the Constitution of India is at the instance of the
Plaintiff number one.
of the why plaintiff number one?
Other plaintiffs I have arrayed.
I beg to appear on behalf of the petitioner. My expeditious hearing of a section 125 application.
Of?
It should be, my lord, I must say, my lord, instead of it should be criminal revision application.
Criminal revision.
Yes, sir.
We want to withdraw to file afresh.
Lord, can it be amended because it's a basically
Numbering and other thing. I think it's better if you withdraw file. It will be better. You can move it earlier, other than transferring. The learned yes.
For the, Your Lordship, the plaintiff is the petitioner. Have come up against disposal of 7-1 and 7-2 petition filed in favor of the tenant. Now, Your Lordship, the ground is kindly come.
It was held defendant is not a defaulter.
Then
This is the first matter which have seen wherein it has been held the defendant is not a defaulter.
But the question is that application is not maintainable. It was barred by litigation.
But if it is, he is not a defaulter.
No, I have two-fold grounds. One, that 7-1, 7-2 is not maintainable because of 30 days has lapsed. After 30 days of receipt of the summons, he has filed it. Number one. And number two, he admits that he has inherited the tenancy through his uncle. 2G, Your Lordship, nephew is not entitled.
I am expediting the suit.
Yes. Impugned order, page 3. Your
Ashun,
Lordship will find.
by the order impugned, the state
Lordship, I am for the petition. Lordship, by order impugned, Lordship, my application under Order 1, Rule 10 was rejected. Challenging that, I have come up before your Lordship. Now, Lordship, the opposite party number 1, as a receiver, Lordship, filed a suit for eviction, Lordship. But he was not taking any steps. Now, Lordship, this receiver, Lordship, was appointed in a partition suit. Ultimately, Lordship, the final decree has been passed on compromise, and this suit property was allotted in my favor. So, Lordship, since now the receiver is not taking any steps, Lordship, Lordship, I filed.
after disposal of the partition suit, the receiver could not have continued.
But he is not taking any steps. And Lordship, I filed an application under Order 1, Rule 10 that has been rejected.
Who are you?
I am the owner now, Lordship. Lordship, kindly sees the order impugned. Order number 47, dated 30th of April 2024.
30th of April 2024.
Yes, Lordship, I
You
have
are
given
coming
the
now.
yes, I have given the explanation because Lordship, even after passing of this order, I was waiting that if he takes any steps, but he did not take any steps.
Final allotment has been made in the partition suit.
Yes, yes, I have annexed that. Lordship, kindly sees. That is, Lordship, at page 23.
Have you stated that fact in the application under Order 1, Rule 10?
Lordship, kindly sees. Yes, Lordship, my application is at page 48, paragraph 1 itself.
That was made prior to the filing of the suit or after that?
After.
After that.
No, Lordship, just give me a.
Addition.
After. Lordship, final decree was passed in 2019. Suit was filed in 2015. Eviction suit.
So eviction suit is an earlier one when the receiver was there.
Yes.
Now you have applied for addition of party.
Yes.
You will be added in what category?
Lordship, as plaintiff. Co-plaintiff. My application is at page, Lordship. At paragraph number 1, I have stated about that property was allotted in my favor. And my prayer is at page 50 as co-plaintiff.
By the
My lord, praying for not this week.
Not today,
Not this week, my lord.
not this week. An accommodation has been paid for by the learned advocate. Please use the microphone.
Expeditious disposal of lordship of eviction suit filed by the plaintiff petitioner hearing. The defendant opposite party entered appearance and filed the WS denying all the.
What is the stage of the suit?
It is in PH board lordship. It's for long time.
This application under Article 227 of the Constitution.
My lord, for the petitioner, Mr. Parthopratim Roy is engaged in another court, my lord. Kindly give us hot pass over.
What is this matter?
Lord, I'm not aware of the facts in this matter, my lord.
Then don't pray for fixing. Don't come tomorrow in the morning for fixing. An accommodation has been paid for on the ground of.
পাসওয়ার্ড ম্যাটার
করতে পারতিস তো মামলাটা
16 ছিল না একটা পাসওয়ার্ড 16
Yes. Yes, Mr. Mukherjee.
But I filed an application under Order 21 Rule 97 in connection with a final partition degree being executed on the ground that the predecessor in title was one of the co-sharer.
The portion has been allotted in your favor, as I have heard from junior Mr. Mukherjee.
I'm not a party.
It has been allotted to you, a portion.
Yeah, to the plaintiff decree holder who wants to execute it in my favor.
No. You said that in favor of your, though your shares were not declared in the preliminary decree, allotment was made, but some portion was allotted.
I'm
to
a
the
third
decree
party to the decree.
He said that.
I'm a third party to the decree. To cut the matter short, I took out an application to say that the property which I had purchased from one of the co-sharers of the partition suit, that cannot be a part of the decree.
That
cannot be part of the partition decree because it was exclusively bought by my client. So they cannot include my property.
Mr. Mukherjee, you have purchased from a co-sharer.
Prior to the institution of the suit.
Yes. So, but maybe prior to the institution of the suit, but you are a co-sharer in the respect.
But I was not arraigned as a party. Therefore, I am not a beneficiary to the partition decree. I understand what your lordship's contention
property
is.
was within that suit property.
A part of it. Yes. So, in preliminary degree, it was the share which was out of the decree. In the final partition degree, the partition commissioner
whether your property was the subject matter of the partition suit.
My property was the subject matter of the partition suit.
Whether
to that extent,
whether any of the co-sharers through whom you are claiming by virtue of successive transfers whether he was a party in the partition suit.
Yes, he was. Yes, he was.
If he was a party to the partition suit, whether in the preliminary decree, shares in respect of him or any of his successors in title was declared.
But so far as excluding the purchase of my client, but it was not subsequently included in the final partition decree by the partition commissioner, to which I took out an application under order 21 to say that my demarcated 85.75 decimal of land, which I had purchased, could not be included into the final partition decree. I sought for a declaration to that effect. But there were 3 applications taken out which were dealt with by the impugned order. Of one application under 151, which is dealt with by the learned judge. If your lordship kindly comes to that.
What is the nature of the application?
Yes, your lordship will kindly come to page 242.
Yes.
Sorry.
42, yes. 243 is the affidavit.
It starts at 239. I'm sorry.
239, yes.
But kindly come to paragraph 3.
Yes.
But these are not the documents. Then paragraph 5. These are not the documents which are not exhibited in a previous title suit between the other parties, and I sought for marking it as an exhibit in the miss case. There are twofold the prayers. Either you call for the records of the other suit, wherein these find as an exhibit, or allow me to mark this document as an exhibit.
A certified copy of the exhibits also.
But that is exactly what
certified copy of the exhibits in that suit.
Kindly have a look. That record is not available. This
record of the title suit is not available.
No, for years.
Is it recorded here?
No,
so what is the reason for rejecting your claim?
Now your lordship will kindly come to the impugned order. Kindly ignore the previous portion.
Impugned order is dated 15th of February.
15th February 2025.
Yes.
An application on affidavit, that is number 3.
No, which page?
No, the first page of the yes.
Yes. An application on affidavit, yes.
An application on affidavit regarding document marked as X and X1 for identification as regular exhibit, being exhibit number 11 and 12 respectively, on the ground stated therein. And thereafter 4, an application on affidavit under section 151 to produce the case record pertaining to title suit number 48 of 1994 and for its inspection. These are the 2 applications. It is required to state herein that no taken of petition has been filed on behalf of the petitioner for taking of the case record for evidence, but on the consent heard both sides at length, then
interim injunction, you are not agreed by that?
No, I am not kindly.
Yes.
Then in terms, after
next
the board
is now the petition pertaining.
Now the petition pertaining for marking document as a regular exhibit is taken for consideration. It is required to reflect the advance by both the parties. Such, then your lordship will kindly come to the considered next page. The discussion above, this court is of the view that the present petitioner is claiming his right over the suit property being the subject matter of the title suit, which already gets its logical end by pronouncement of judgment and during its execution process. This miscase cropped up wherein the petitioner has claimed that they had purchased the property from the vendor, being the contesting defendant in the original title suit.
So your vendor was a party?
Yes.
Your vendor was a party and you have purchased after the final degree?
No. Prior to that, I purchased.
Because it says that vendor never challenged the final degree of the original suit. It must be you have purchased after the final degree.
I am not a party to the final degree.
No, but your vendor was a party.
Yes.
But Mr. Mukherjee, your vendor was a party, so they may not know that you have purchased. So you had a duty to inspect whether there was any pending proceeding was not at the time of purchase. That was your duty.
I purchased in 2006.
When the final degree was passed.
And the final partition 2008.
So after that?
After that. No, I purchased before that, 2006.
Yes, decree was passed after that.
After that.
So you also had no knowledge.
I had no knowledge. I was not a party.
But they also did not have any knowledge that you have purchased. Your vendor also did not
No.
disclose. So, Mr. Mukherjee, so you are bound, since your vendor was a party, so you are bound by the decree. Can you challenge the final decree now?
Lord, I say that I am not challenging Lord, the final decree Lord, in its entirety. I am seeking a declaration that 85.75 decimal out of Lord, the decree
Mukherjee, that
is Lord, a
I appreciate.
property that I
Yes, but that is, you cannot claim beyond what your vendor was declared or allotted. You are bound by the allotment of your vendor, because your vendor, neither you nor your vendor during the pendency of the suit disclosed this fact. You did not take any steps under Order 22, Rule 10. The law is, it can proceed. You will be, if you are not implemented, you will be bound by that order, decree. So decree, this is the recording that you will be bound by the decree or the final decree passed in favor of your vendor.
But I'll just Lord, try to put it in a different way. But suppose Lord, my vendor who suppresses about Lord, the sale and takes a degree in his favor about Lord, the partition. But I being a purchaser from him, but am I not entitled to take out Lord, application to say that this is my exclusive property and it cannot be brought within the hodgepodge of Lord, the final partition decree? This is a question I raised to myself.
Mr. Mukherjee, can you take that plea being a transferee pendentility? Can you take a different stand from that of your vendor?
No, I do not say, Lord, that. But I say that the vendor had his share. And I had a demarcated share, Lord, purchased from him. So,
Yes,
Lord, all
but
that I say...
Mr. Mukherjee, that is between you and vendor, not the other parties.
That is exactly, Lord, what I say, that you cannot include 85.75 in the final partition deed.
No, Mr.
Final
Mukherjee,
partition deed.
there are two aspects. If this 85 point something, what is there, your vendor had a larger share than, had a larger quantum than this 85. So you are bound by the inter-se allotment between you and your vendor with regard to 85 and more than 85. But can you claim anything, dehorse the claim of your vendor as against the other
That
parties?
is, Lord, the vendor is having, Lord, a declaration as of today, Lord, in respect of, Lord, the property which includes my share, that is 85.75. Let us.
Judgment, page 155.
Now, Lord, the other portion is, Lord, that whether, Lord, this particular documents which I, Lord, sought to, Lord, have it exhibited, Lord, those are necessary for the purpose of adjudication. This is an interim order. This case is yet to be decided.
Mr. Mukherjee, what do you say to Order 21, Rule 102?
Lord, no suit can be filed.
No, nothing in this rule. Kindly take off Order 21, Rule.
Lord, I'll just have a look.
You can take this. Din.
Lord, I have. Oh, I have.
ঠিক আছে. Order 21, Rule 102.
There is nothing in rule, Lord. Lord, this is, Lord, I say, Lord, that it is not a transferee pendentility in that sense.
Has to be. Because
Resistance
this
to
transfer was
obstruction.
during the pendency of the suit.
No, this is, Lord, the suit was filed, Lord,
1994.
1994.
Pendency of the suit, final decree
But 67, the first deed was executed, and that was one of, Lord, the issue.
Mr. Mukherjee, you have purchased during the pendency of the suit.
But that
why
was
Order 21, Rule 102 is staring it at your face?
No, Lord, the page
Nothing in rules
155.
98 to 100 shall apply in case of this.
But your Lord, if your Lordship kindly comes to page 155, your Lordship will find, Lord, there's a sale deed of 1967 was my lord one of the subject matter of my lord the preliminary decree. This was my lord.
Now what happened?
Thereafter, my lord, the learned judge, my lord,
And that should not be part of
67, my lord, that deed was held to be a valid deed, and thereafter, my lord, I have purchased, my lord, the property, my lord, in 2006.
So your prayer for bringing that deed was rejected.
That is. Therefore, whether that deed is a necessary, my lord, or document, to
You are
prove
praying
my case
for
or not.
bringing which deed, by virtue of which you have purchased?
No, the 1967 deed.
1967 deed. It's the original deed or a certified copy of the deed?
This is the certified copy of the deed.
Because the original was marked as an exhibit
Yes,
there.
in that suit. That was. And I don't have a, my lord, a certified copy with me. Acha. File. I filed the certified copy to be marked as exhibit. That I will not. I will check up, Lord, because at a later stage of this proceeding, it might crop up because the ultimate purchase was in the year 2006.
So
that will
you cannot avail of Order 21 rule. You cannot avail of Order 21 rule 98 and 100.
That will check up, Lord. In course of Lord, because now that question has not cropped up. It is your lordship
Goes
has
to the
pointed
root,
out.
Mr. Mukherjee, of your proceeding.
I
very
did not look
initiation
into
of
this aspect. I didn't look into the aspect.
by the
On PM, there is a matter being fixed by his lordship.
matter, which matter?
That Vishwabharati.
Yes, yes. Will be called on. It's not yet 115, it's 114.
Lordship, the execution case also be stated. My miss case along with the execution case. Connected execution.
If the miss case is not decided, can the execution be continue, Mr.
Now, in the miss case, there is a stay of execution.
Miss case, there is a stay of execution.
Then miss case, if it is stayed, automatically that will be stayed. And if the miss case is pending, can the execution proceed?
I'm grateful.
But see, Mr. Mukherjee, with regard to your
Lord, that
mentality,
is the point, Lord. I am grateful to your lordship, Lord. I'll go through that. If we find any difficulty, I might advise, Lord, a different course of action.
Lord, I am appearing on behalf of the state.
Lord, I am for the municipality.
you are for the municipality. What are you doing, Mr. Rai?
Hello?
What are you doing? They are rushing
No,
from yesterday.
it's against the Vishwabharati. Against the Vishwabharati. The main grievance is against the Vishwabharati.
You are for Vishwabharati.
No.
You are for the municipality.
The grievance is against Vishwabharati.
Yes.
I'm appearing for the Vishwabharati. Even against the state, against the municipality, even Vishwabharati is also filing a writ petition that will soon be filed.
Against the municipality, Vishwabharati has also filed a writ petition.
Going to file, rather.
So what are you trying to do? Don't do anything in the meantime. I will direct both these writ petitions to be tagged.
But the difficulty is, Malad,
Yes. What are you doing? What he is doing?
Malad, kindly come to page 36 once.
page 36. Everything will be clear. This is a plot of land.
What is the because
Yes,
Mr.
my lord. I'll take only 1 minute. My lord.
Yes.
Only 1 minute. Lordship find at the, if your lordship take the matter in the landscape manner, my lord
Yes.
find at the northeast corner there is a road. This is a public road, Bolpur Sriniketan Road. And this road, my lord, approaching another road at the top. This is approaching another road. This road is, my lord, belong to Vishwabharati.
Road belongs to Vishwabharati. Both the roads.
No.
This one.
This one,
Yes.
there is a gate.
Yes.
But the petitioner, this particular plot also belonged to Rabindranath Tagore, who sold the land to Satyendranath DC. Satyendranath DC sold the land to Dhirendranath Sen. Dhirendranath Sen is the first election commissioner of independent India. Now, my lord, I purchased from the legal heirs of Dhirendranath Sen. This road used by the predecessor of the petitioner and the petitioner for last 70 years. Now, my lord, there is another road which is at the bottom. Now, what happened? And my lord, this portion of the plot, there is a drain.
Yes, yes.
Now, my lord, the entire water, my lord, from Gurupolli, Shimantopolli, even the Vishwabharati, those water, my lord, locked into this drain. And my lord, there is this pass through this way to Hatipuk. It's a big water body. Now, what happened? The dispute comes. This is my land and this is a road. The area beside this road belonged to Bolpur municipality. Vishwabharati first did, they raised a boundary wall on the periphery of my road so that I cannot access to this road.
So it has been constructed.
It has been constructed. I have raised up several complaints, but now, Manat, it has been constructed. Now, Manat, the first difficulty, there are two writ petitions. The first one is for the road
removal of that construction.
Removal of construction as well as just to access the drain. Otherwise, the
access
of drain to the main.
Yes.
Because otherwise, during the monsoon, the entire water locked into my plot. This is the first thing. Second,
so this construction is made only in front of that drain.
The periphery of my boundary wall here.
Entire. Yes, yes. Then
now, Malat, what happened? I have filed a writ petition that is Malat,
for removal of that construction.
Just to give me the access, not for removal. Give me the access to the street, and as well as to give the access to the drain, to the main drain, so that the water can be passed. This is the first one. Second one is, Malat, now the urgency remains. Malat, the second writ petition is filed in apprehension that they will going to close this gate as well as this road. Now, Malat, after some place, it mixed with this road. Now, I have the apprehension that they will going to close this road also. This is in apprehension. Now, what happened?
So, this is the urgency with regard to closing of this.
Malat,
yes, what is your instruction?
Only thing, Malat, only thing, Malat. Now, they are already, Malat, started digging the earth to this road so that I cannot access from the northern side. This is, Malat, the photographs.
Yes.
My only prayer, I want to access my property, nothing more, Malat.
Yes, Mr. Bhattacharya, there are two things. One is,
and Malat, so far as the Malat whether this is Malat, due to the long uses, I must say, Malat, this attains the definition of public street. I can satisfy, Malat, but for today, Malat, I will not disturb Malat with all this thing.
Yes, what is your writ petition? You have filed.
No, I have not filed, Your Lordship, yet. Your Lordship, my instruction that this property belongs to the Vishwabharati, Your Lordship.
Yes, yes.
That's why I have created those fences.
Malat, I have the deed, I have the record of right, I have the sanction plan, I have, Malat, the current rent receipt, everything, and even, Malat, I can show the map of the Vishwabharati, Malat, which is in their website. This map says that this property does not belong to them. And it is
that is
a title dispute. I am not a title dispute. If they have anything to say about my title, Malat, the appropriate forum will take the decision. But this is not a Malat way to Malat block my access.
4600, that is the first one. That
This is the
is,
drain.
that is with regard to the drain.
That is in respect to the
So
drain.
that construction has already been made.
It is already made.
That is the other.
So far, the first writ petition, no copy has been served to the municipality.
So what is it? You have not served copy.
No, I have instruction.
Means both the writ petition I have served.
Second
But I have
petition I have.
the service, sir.
First writ petition, I have.
And what is the?
So far as the second writ petition is concerned, that is in apprehension that they will close the access from the northern side. That is in respect of the other plot, where I have the access from the northern side road.
Yes. What is your instruction with regard to this?
My lord, I've been instructed that the property of the petitioner is not being fenced. My lord, fencing is going on from a distance. There's a distance between the petitioner's plot and the fencing work which has been going on. Now the problem is, my lord, the petitioner's plot is situated and it's surrounded by Vishwabharati properties, my lord, on all sides. Now, my lord, the plan which has been obtained by the petitioner from the Bolpur municipality, but we say, my lord, we have taken initiative. This was not in our knowledge. After they have been served with this writ petition, they inquired, the Vishwabharati authorities inquired, my lord, this plan itself is illegal.
Which plan?
The plan of the property belonging to the petitioner, my lord,
that can be decided. So can you not stay your hands for?
My instruction is that, my lord, we are not fencing the petitioner's property.
No, kindly come to the second writ petition, his prayer. On the northern side. So northern side, are you constructing on the northern side?
Northern side is the Vishwabharati road. It's a private road belonging to the Vishwabharati northern side. That is my instruction.
Yes.
It says that it will obstruct his ingress and egress.
No.
Because they have, but I have given them the notice. They are
to taken instructions with regard to this.
In the northern side, specific instruction is that on the northern side of this property, there is a road, and that road it's a gated road. The private road of the university is gated for the life.
Put a gate is one thing. If you construct a boundary wall, then access is closed.
No. Boundary wall has not. I have been giving
closing the gates and the boundary wall, restricting entry.
I have taken the instruction. If your lordship pleases, kindly appoint a special officer to go and inspect.
Come at 2 p.m. Why? 30? 39. 39 was called on, and adjournment has been paid for on your ground.
My lord. My lord, kindly. My lord.
This happens with busy councils, Mr. Rai. Your juniors have to start. They are not starting. Busy councils have to ask these juniors to start. They will only come for the final touch. That is what you are doing.
My lord, before rising, my lord, kindly do not take me amiss, my lord, pursuant to item number 5, my lord was pleased to release it today morning, my lord. I have wrote a letter to the assistant secretary of the Chief Justice, my lord. He has advised me that until and unless the file is released by 31st is the interim order expiring, my lord. Item number 5, my lord.
When the order was passed?
In the morning, my lord.
So
I have wrote a letter, my lord. They are suggesting me that until and unless.
Not yet.
My lord.
Reason for after this is. Please give some time.
31st is the last.
Please give some time. There is some time. They are also in court. Some time is required for typing these judgments. In the morning, order was passed, and you are now complaining that order has
not
not been
complaining,
signed.
my lord. I'm just requesting, my lord.
Please give some time. Item number 95. ডিভিশন বেঞ্চটা কটায় আছে দেখি, লিস্টটা দেখি, ডিভিশন বেঞ্চটা কটায় আছে দেখুন তো। ডিভিশন বেঞ্চটা কটায় আছে? 3:30 না 3:00? 3:30? 3:30? After? Take a chance at 3, then if not after 3:30. if I accept your submission, an authority under Article 12 claiming to be the owner of a particular property wants to construct some road or something. So how the municipality permission is not necessary? There is no inaction on the part of the municipality either.
Drainage and sewage is a part of the municipality.
No,
And my lord, municipality.
Show me the inaction on the part of the municipality.
Because my lord, so far as the drainage.
Your allegation is that a road is being constructed.
No, in my first writ petition.
First writ petition, it has been constructed. Second one, what you are trying to say that.
First writ petition, the Vishwabharati raised a boundary wall over the periphery of my road, blocking the drainage. Now, why the inaction of the municipality? That is because municipality has already sanctioned a drain and road project over this particular property, and I have intimated the municipality that look, the Vishwabharati is blocking the.
No, where is that municipality's project? Where is that?
Yes, I have
in which matter? In which matter?
My lord, I have an explanation. I'm just showing.
In which matter?
In my lord. In the first matter, my lord, 4600.
Yes. Show me the project of the municipality.
Page 35, my lord.
Page 35, yes.
Construction of connector road from Vishwabharati Gate to Nisha Lodge, which is, my lord, my lord, over the drain.
No, this is construction of a road.
Road and, my lord, road over the drain. Road.
Where do you find over the drain? Construction of connector road from such and such gate.
Kindly consider two.
POQ for construction of concrete drain.
What is the project? They will
construct a drain.
Thereafter by putting slab over the drain.
Yes, covered drain.
Covered drain.
Yes.
This is the project which has already been sanctioned by the municipality.
Yes.
On my plot of land. Now,
on your plot of land.
On this nala, the area nala, this nala.
That is not your plot of land.
The nala is also belong to me. Portion of nala belong to me, and portion of nala belong to Paschim Banga. The record of right, I will show malad. It is recorded at Sadharone Bhavarju. So when they are making boundary wall
is one thing. It is, you are saying, please don't mix up this. One is you are saying that it's the project of the boundary wall by the municipality.
No, not municipality. Kalyapishan.
So Vishwabharati, that is, there is no inaction on the part of the municipality with regard.
Yes, because the drain has to be constructed by the municipality.
Yes.
And the boundary wall, by closing the drain, it is the duty on the part of the municipality to remove the boundary wall. Because
that is your representation to the municipality in this regard.
Yes. I have. In the second writ petition,
we are on the first. Let us proceed one by one. In the first writ petition, where is your allegation with regard to that?
My lord, the representation I have annexed in the second writ petition, my lord. Before the chairman Bolpur municipality.
Yes, so here there is nothing. In 4600, there is nothing. Let us see the next. 4614. Where is the
representation was made?
Yes, show me that representation. Yes. Show me only the allegation against the municipality.
Yes. No, I am just bringing it to the knowledge of the municipality. I bring it knowledge to the municipality.
Yes, but bring it to the knowledge of the municipality regarding that they are blocking the ingress and egress. That is a different thing. How can the municipality do anything with regard to this?
That is the reason, my lord, I have filed under Group 9, my lord. A ladyship
here, if it's that is, you have to apprise the honorable judge under which here there is no inaction. Show me from your representation inaction of the municipality.
I am basically my allegation against the Vishwabharati that
then
yes,
Group 5 there is no inaction. So how can it be entertained in Group 5?
I understand, my lord.
Then
That is the reason, my
you
lord.
should have pointed out that it's not a group 5 matter, but you have accepted that.
No, my lord, I have not accepted, my lord, but
Because you have accepted that. According to your own showing, you moved that base. So there is no inaction on the part of the municipality. Cannot be a group 5 matter.
my lord, because, my lord, I tell your lordship, my lord, while filing this application, I have checked, my lord, I personally checked, my lord, the subgroups. And in the subgroup, there is nothing on the part of group 5. I understand, my lord, I understand. But, my lord, lordship, kindly appreciate my predicament, my lord. That is the reason, my lord, I filed before the group 9 bench. Lordship, kindly see my presentation form.
Mr. Bhattacharya,
I understand,
that is the difficulty. You should have pointed out.
My lord, with due respect, my lord, I tell your lordship, my lord, I had pointed out the matter. But since there is a...
Then you have to challenge this order. Because prima facie does not, there is no inaction on the part of the municipality. How can it be a group 5 matter?
I understand, my lord, but
so if prima facie I am not satisfied, group 5, I also cannot take up this matter. Because only that determination has been assigned.
I understand, my lord, I understand. But lordship, kindly appreciate...
Then you have to challenge this. Either you can, I can release this, you can apprise leadership that this is the fact.
My lord, difficulty is, my lord, now, my lord, my northern side is, my lord, only one thing, my lord. Kindly, my lord, protect me from my northern side, my lord. I understand, my lord.
See, if that is not there, how can I pass that order? That is what is troubling me. Because now, prima facie, your relief is only against Vishwabharati. So if that is so, the municipality,
because
merely by including the municipality, it does not become a group 5.
My lord, I made municipality party only to, my lord, that municipality is the custodian of the records. That is the only reason.
I think that weighed in the mind of his leadership that since you have implemented
Yes, that is the reason I tell you.
That you have to point out that no relief I have claimed against the municipality. This is the limited purpose, not a necessary party, but a proper party. That you have not done.
Specifically, it is submitted that the relief is only against Vishwabharati.
If you want, you can challenge it.
The difficulty, lordship, kindly appreciate the difficulty of a litigant, my lord. Kindly appreciate this. My northern...
But not group 5 cannot be entertained. That is the difficulty.
No, my lord, so far as the second, so far as the first matter is concerned, this is in connection with the drain. While, my lord, I have not and even annexed the representation of the municipality. But so far as the second part is concerned, I have annexed the representation of before the municipality because, my lord.
No, which matter you are saying?
The second matter, my lord. Kindly come to
4614.
Yes.
Yes, 4614, that representation. Where is the inaction?
No, representation is now my lord, kindly appreciated for a different angle. So far as the road is concerned, as per Bengal Municipal Act, this road is now a public street. I can show to your lordship, my lord.
No, you said it's the property of the Vishwabharati. So if it's the property of the Vishwabharati, then is the permission of the municipality necessary? Then
no, my lord, I tell your lordship, my lord. What I am trying to satisfy, my lord, that even if a property, a road of a private body or even Vishwabharati or even a private body, but this road is used by thousands of people for last 75 years. It automatically, it reach the status of public road. Kindly consider section 251 51 of the Bengal Municipal Act. Now, the municipality is the authority who can protect the public road under section 166.
So where is the representation you have stated that?
In the representation, I have apprehend the...
But you have stated, you have to approach the municipality saying this.
I have approached the municipality.
Show me this part, that is the road, municipality is the custodian, something is being done. You have to ask the municipality to take steps. Because, Mr. Bhattacharya, that is the basic purpose of a demand of justice.
Now, let kindly consider
it's only allegation, Mr. Bhattacharya, prima facie it appears against Vishwabharati. Nothing related to the what we are now submitting. That is not the case made out in the representation. হ্যাঁ? হুম, ঠিক আছে, তাহলে একটা কাজ করো। করবে না? Yes.
Malad, kindly consider page 118, third paragraph. Wait,
Page
118, inner page
18, yes.
third paragraph.
Yes.
It is to state and submit that the petitioner and the KRJ Properties LLP are the rightful owner of their plots of land and the same are not within the purview of Vishwabharati. Further, the roads which comes within the jurisdiction of the Vishwabharati is used by the petitioner for the egress and ingress from the said property of the petitioner. The said roads are being used for the said purpose for a prolonged period of time, even by the erstwhile owners of the said plots of land for egress and ingress to the said property. Therefore, it is pertinent to state and submit that the said roads are parallelly used by the petitioner for their necessity. It is to further state that there is no alternative to the petitioner for their ingress and egress from the said property of the petitioner. Now, therefore,
Next paragraph. Mr. Bhattacharya, entire allegation against Vishwabharati, nothing
Malad,
to
yes,
bring.
Vishwabharati is the Malad, acting like a land grabber.
So that is the sum and substance of your representation.
Yes.
So no allegation against the
Malad, can I
municipality.
appreciate Malad, it is the municipality who is Malad the
You
authority.
have not pointed out this in the representation. How do they know? Entire allegation against the Vishwabharati. What you are not submitting, you have to protect. Show me nothing.
That is not
Then-
there. That is not there.
Then,
And that
how
is
do-
the reason, Malad, I very candidly say, that is the reason I filed in the group 9.
Mr. Bhattacharya, what is the purpose of demand of justice? What is the reason for that? Or what is the-
Demand of justice basically made to the Vishwabharati.
Yes, but no, I'm not on that. Before filing a petition, why do you give a demand of justice? Because for that authority to see your grievances and to take steps so that a litigation is avoided. That is the whole object of the demand of justice. So from this, a reasonable man cannot find anything against the municipality.
I agree, Malad. I agree. I agree. Because Malad, my representation is against Malad the Vishwabharati.
Yes, that is why. So
I
nothing, no allegation against the municipality.
But Malad, also kindly appreciate if they able to close Malad my front.
I'm signing it just now. I can sign it
Then
just now.
Malad, kindly make only one observation that this is not come under group 5 and this is under group 9, Malad. Kindly make these observations.
In both these matters, I am
Both
making.
these matters. Because Malad, otherwise, Malad,
Or Mr. Bhattacharya, I can give you this chance. I can adjourn it. You can try your luck before the regular bench.
so Malad, the same issue will come, Malad. Same issue will come. Because I know, Malad, what the case make out in the petition. Kindly make some observation that this is a group 9 matter.
আসুন 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 ওই দুটোতেই সেপারেট অর্ডার করবেন কিন্তু মোটামুটি এক হ্যাঁ
আমি আজকে দিয়ে দেবো
copies will be given to you. Mr. Bhattacharya, please give
I
him a
will hand
copy.
over, Malad. I already told him. Malad.
After going through the averment
of 400 passed in the year 2018.
Kolkata Corporation Act. Yes.
Passed in the year 2018. Malord, would kindly see the document for my satisfaction, which is at page 67 of your Lordship's brief. Page 67 of your Lordship's brief. Your Lordship would find this is an order under subsection 8 of 400 seeking demolition. I am placing from the top. This is a case of unauthorized construction of 2 RCC slabs at front portion at 5th and 6th floor level. Commercial building including installation of lift. Notice under 401, nothing done. Now your Lordship would see subsection 8 of 400. It talks about immediacy and urgency. Notwithstanding anything contained in this chapter, if the mayor in council is of the opinion that immediate action is called for in relation to a building or a work being carried on in contravention of the provision of this act, it may, for reasons to be recorded in writing, cause such building or work to be demolished. My lord, forthwith. Now, my lord, I emphasize on the words immediate action and urgency.
And forthwith.
Yes. Now, I have also, with that, I have shown my lord, page 67, that this has been passed in 2018. Now, my lord, would kindly take my statement at paragraph 27, page 13 of your Lordship's brief. Paragraph 27, page 13. Page 13 of your Lordship's brief. My lord, we are on the balance of convenience and my lord, grave prejudice.
So why the honorable division bench?
My lord, there I tell you, Lordship. I have purchased this, my lord, the place where from I done my expense, I purchased in 2023. Now thereafter, the private respondent number 10 made certain allegations before the corporation that there is illegal construction. Then he filed a writ petition. Now, my lord, that writ petition filed by the private respondent number 10 has been disposed of, my lord Justice Kauchik Chandra, which your Lordship gets at page 66A. My lord, I will not trouble your Lordship with the entire order. Your Lordship would come to internal page 266B, the last paragraph. I do not find. Oh, my lord, the second paragraph, report was called for from the corporation. The report filed by the corporation indicates that the building in question is substantially old and fully occupied. That apart, corporation did not say anything. Now, my lord, the last paragraph. I do not find it appropriate to entertain this writ petition, primarily because I am not satisfied with the bona fide of the petitioner. The petitioner claims that he resides approximately 5 minutes walk from the property. However, the petitioner has failed to demonstrate how he has been prejudiced by the construction of the 5th floor. It is undisputed that the 5th floor existed in 2017. The petitioner claims to have been repeatedly lodged complaints with.
Mr. Mukherjee, this writ petition was at the instance of the private respondent
Number 10.
praying for implementation of the order of demolition.
They were praying that I have made complaint, you have not done your act.
Yes.
What you are supposed to do under the law.
Yes.
Not 408 or 401, nothing.
No,
I have made complaints. The corporation is not going into the complaint.
All right.
And that was the writ petition. And now
So that was dismissed.
that was dismissed.
Against that,
an appeal has been filed.
yes, what happened to that?
Nothing has happened. Appeal is pending. Now what has happened in the appeal? My lord,
You are a party in this.
I'm party.
Yes.
Now, my lord, in appeal, this page 67 has been disclosed. And I come because this is 2018 document.
This has been disclosed by the corporation.
No, by the private respondent number 10. This is a document of 2018. My deed is there, my lord. I have come into the property in 2023. So in 2023, I cannot have know of a fact which happened in 2018. Now I come to know for the first time from the appeal. And very surprisingly, after the appeal has been filed, that paragraph 27.
Yes.
Since the appeal is running in the list. Now, my lord, balance of convenience and prima facie
If
case.
the appeal, Mr. Mukherjee, is running in the list, why don't you approach the Honorable Division Bench?
My lord, I would be, but because this is not there in anywhere.
No, this was disclosed
In appeal. But
in
I
appeal.
cannot challenge this document in the appeal court. I have to knock the door of the trial court.
So it's better this writ petition has to be heard by the Honorable Division Bench. Your challenge, because since the matter is in
My lord, your lordship
that large before the Honorable Division Bench.
take judgment, 3 paragraphs.
For
3
what?
paragraphs
For what?
on whether this subsection 8 of 400.
I'm not on merits, Mr. Mukherjee. What is troubling me is that this order, which you have challenged here, that is being placed before the Honorable Division Bench. So that is
The documents
the
are
appeal.
in the state.
I accept your submission that being a respondent in the appeal, you could not have challenged that order. So I think it's better that this writ petition has to be heard by the Honorable Division Bench. Otherwise, there will be conflict of judicial system.
I do not have any difficulty. Your lordship takes note of, at least take note of, it's a very short judgment. Take note of last 3 paragraphs and at least restrict corporation for till the time division bench takes up this matter, not to proceed in terms of subsection.
Yes, who is appealing for the corporation?
Mr.
Mr. Ghosh, you are sitting there.
Last 3 paragraphs. Act minute. All of the acts. Last 3 paragraphs. In the meantime, this is the judgment of 2000 reported in 2014 SCC Online Calcutta 16044. Sai Impex Private Limited versus Kolkata Municipal Corporation. Well, the last 3 paragraphs, it's a pat on the point, it fits in my case. Court directed that this subsection 8 of 400 cannot subsist. It has to be changed into subsection 1 of 400. After all the passage of time. Because there, as I have said, my lord, at the outset, there is no immediacy and urgency.
Yes, Mr. Ghosh.
The order,
Yes.
the case of one of the construction of RCC there, one portion of the existing factory. Therefore, that was a state power and a factory building, and then 3 tons explode. That means about 6 story and 7 story building was started. The order was passed on the 2018. The Partition is there, that will be executed.
18 na 17.
Mr. Ghosh, why it was not executed for these long years? Why it was not executed?
And for that reason, one can say that the order is passed on, that is that can be the ground for asking for because order A or immediacy, urgency, footprint has been categorically dealt by the division bench. But taking into account that judgment or file under the cited to the simplex judgment that was taken into consideration and judgment was basically 2024. That was the court order has the state can consider is two benefits of taking into account the issue and also those
already executed cannot exchange.
Where is that?
That was found that have got the immediate
No, Mr. Ghosh, when are you contemplating to demolish? When are you contemplating?
But when the matter is good, it's your
But if in the meantime you demolish,
Who is going to demolish?
Mr. Ghosh, till this time you have not done anything. From 2018 till 2025. No. Maybe for ABC, Mr. Ghosh, maybe for, I'm not saying that this has to remain. But from 2018 till 2025, 26th of March, you have not demolished. So, when the division based the matter is appearing in the list.
It is in the
Melod,
even it is in
Melon, may I just indicate these are not at all correct. Let him complete, I will submit.
adjourn it for 5
No.
days.
Agar list
Last
now.
day for 5 days.
Check.
Heaven is not going to fall down. And we'll mention it tomorrow and tax.
Now,
with the
Melod, kindly allow me to submit now. What has happened?
Yes.
Which?
No, I've seen that.
The court because he had the knowledge and information about the order in 2017.
No, Mr. Ghosh, even if there is the writ petition is dismissed, the petitioner's hearing cannot take a stand that this order goes. This order still remains and it can be executed. I'm not on that. But since, according to the petitioner, they were not aware, they came to know about this order only on during the pendency of the appeal.
Yesterday,
So, Mr. Ghosh, there is two things. If a party becomes aware, that is his statement, unless you can show, Mr. Ghosh, unless you can show they were aware of this order, there is nothing. It was only disclosed by you in the appeal.
Not them, my lord.
All right, by him in the appeal.
Because after I got the petition, I don't know about the all that I got my questions to me. I can really answer all those things. But the thing is this, my lord, what is the contempt right now? Has he
Para 27.
Somebody comes or in a way, but if of the construction is there, then he may proceed.
All right, yes, Mr. Gupta.
Now, my lord, these facts which have been placed before your lordship is not.
Who are you?
Now, my lord, I filed the writ petition.
Who are you?
I am a adjacent owner, filed the writ petition. The stand taken before the honorable single judge by my learned friend, who is seeking an order now, was that there has been no illegal construction at any point of time. Kindly come to page 66. It is based on my learned friend's submission, the writ was not entertained. Kindly look to his statement which is being recorded. Page 66b, my learned friend's senior friend has placed 4th paragraph. Kindly take trouble to have a look to the earlier paragraph. Mr. Biswajit Mukherjee, the learned advocate for 17, he is the writ petitioner here, submits that the building has consistently been recognized by corporation as 5-storied building structure. He further states that the building has been mutated in his client's name in corporation assessment record and that his client has been paying property tax. Now, who is this
Respondent number 7, kindly have a turn to his own writ petition. Paragraph 3. Respondent number 70. He is the writ petitioner here. He kindly look to paragraph 3. His deed of conveyance is dated 29/2023. This writ petitioner has purchased the property on 29/2023. Prior to his purchase, there were other owners who also sold out. There have been 3, 4. Whenever it was sought to be impugned, the another comes in. Now the question importantly comes before your lordship. His owner also purchased the property. There has been 3 registered deeds with respect to this property. These 3 owners, that is his predecessor in interest, who suffered that order in 2017, did not assail this order at that point of time. Now while this retained in the registered deed, which were 3 in number executed, they went on projecting as if 5th floor has sanctioned. The specific my case was that it is not slab, it is 5th floor which has been constructed illegally. The stand taken by this petitioner and the other erstwhile owner that there has been no proceeding by corporation pending. Court my lord invited me to file some document to show that you are aware of this. At that point of time, it was not with me. I went to corporation, whether they can under RTI Act. They provided me.
This you got by RTI Act?
I got it. I relied it before the division bench that the stand taken by corporation as well as erstwhile vendor, including this petitioner being purchaser, are on the face of it incorrect. In the registered deed, they projected that 5th floor has been sanctioned. No sanction plan exists with respect to 5th floor. They want to mean it that in the garb of this order, the extent of construction is only RCC slab. If your lordship, my lord, wants to entertain, anybody can be deputed who will find an entire floor being constructed as 5th floor, which has got no sanction plan at all.
Sir, Gupta, don't strain your voice so much. There is microphone. Why are you straining your voice?
Extremely sorry. There is no sanction plan with respect to 5th floor. Yesterday, the matter was taken up before division bench. Why this urgency has cropped up? The division bench called for a report, though it was not recorded in the order. But the learned advocate of the corporation, prayed for 1 day's time. Because it was listed tomorrow, he was not in a position to address it. Therefore, when
it has been fixed?
Today it was fixed. It is running in the list. 93. Today, 93. It was taken yesterday.
Directing this writ petition to be...
that can be done. But one thing which is coming in the way, this is for your lordship, because adding this writ petition...
Since this issue...
No, your lordship is absolutely correct.
Since this issue is there,
I will not...
One thing, you are trying to rely upon this order of 2018. He has, according to him, maybe he is right, he is wrong. You can show from the documents he was aware, his predecessors were aware. That is a different thing. That is on merits.
Your lordship's
So
view
since
is...
you have challenged...
Your lordship's view, my lord, is acceptable. There cannot be one thing...
So I'm directing this matter to be placed before the division bench.
One thing. The urgency has cropped up for the reason that yesterday, the learned advocate representing state pointed out before the division state. I do not know whether he is here or not.
All right, yes.
He, my lord, pointed out an affidavit filed by state, and he stated that there are three criminal proceedings of past period with respect to demolition of 5th and 6th floor.
I'm not saying anything with regard to criminal proceedings, but with regard to this.
And there is a doubt, in my view, my lord, the writ petition cannot be entertained at the instance of a purchaser of 2023, because this order
2018.
No, there has been 3 registered sales.
All right. So
now when the original one suffered, And he
So
accepted.
there is one difficulty. If I entertain on merits.
No,
some
your lordship is
observation-
right, my lord, I should
Keeping
not.
everything, I will record all your objections.
Your lordship is right that this should be tagged because the issue is
Landlord, kindly see page 63. Before I purchase, I have inquired with RTI whether there is any demolition order is pending or not. KMC RTI is like this is nothing. I'm not that I have purchased.
So you are also a party in that.
yes,
division,
yes.
eh?
Court did not rely upon that these are incorrect.
One thing,
Therefore, let this be tagged with that. To that extent, I have no difficulty. But fact,
demolition execution.
which attempt finality against two
Yes. 4 minutes, Mr.
Yes.
Tomorrow, kindly direction of
Thank you.
Adult son was awarded alimony under section 26.
Mr. Rai, you can wait till tomorrow.
Yes.
Yes, Mr.
I can wait.
কালকে রেখে দিন ওটা।
Sir, this was the last order we prayed for adjournment, what the court is recording.
Yes. Yes. What is this matter?
This matter is, amendment application allowed at the trial stage. During the cross-examination of defendant number 1, they brought in this amendment application that was allowed. And we have challenged that before this honor.
Have you served?
We have served. Twice. Prior to mentioning, after mentioning.
What is the your prayer for amendment?
No, their prayer for amendment allowed. I am challenging the amendment. $95. Huh?
Plaintiff got knowledge during the.
No, Milord, that is exactly my point. My lord will find, at the time of cross-examination, prior to that, the deed of gift which I relied upon, from which I obtained, my predecessor obtained the title in the property. Milord, that was in that deed. The reference to this deed which he tries to bring in now was referred into that deed. And by way of discovery, Milord, he had the copy of those deeds. This is first point. Second point was, Milord, the suit was for Milord, usage of a common passage. Milord, admittedly, he admits in plate that he is owner of A schedule property, and Milord, the B schedule is with me, and the common passage. Now I am trying to block that. That was the limit and scope of the suit. Now, Milord, by way of this.
So this was after the commencement of trial.
This was after the commencement of trial, and the knowledge of this deed, Milord, he got from the deed of gift deed, Milord.
By the order impugned the application for amendment of plaint. Which is for 3. Tomorrow, your matter is fixed on day after tomorrow. Please come tomorrow.
Grateful, man.